You may be seated. Thank you. Good morning, everyone. I feel like Columbus today. We're going to set sail in a minute. We're not sure where we're going. We're not sure how we're going to get there. But when we get finished, we're going to be excited. Okay? So, good to have y'all. This hearing will come to order before the commission today as docket number 26008 TF, which is styled in the matter of the application of Entergy Arkansas LLC's Generating Arkansas Jobs Act annual updates. This hearing was rescheduled by order number 4 in this docket on April the 7th, 2026. Concerning cell phone usage, if you need to use your cell phone, step out in the hall. If it's on, turn it off. And I think not to bother anyone else or interrupt the hearing today. For the record, will the attorneys state their appearances and the names of those persons they intend to call as witnesses?
Good morning, Jana Law, and I have with me Cesar Caballero and Micah Goodwin, and we have 3 witnesses today, Matt Morey, Matt Clutcher, and David Palmer.
Thank you. Ms. Chandler?
Dorley Chandler at the AG's office. I have with me Michael Lewis and Michael Coots, and we are calling Greg Meyer today.
Ms. McQueen?
Kelly McQueen, AEC.
Let's make sure that's on. Is that mic on? Yeah, it is. Just get closer to it. Remember, you have to eat the mic when you're here, okay?
I know, I forget between hearings. Kelly McQueen, no witnesses for AEC today.
Thank you, Ms. McQueen. Mr. DePippa.
Joel DePippa for the Arkansas Advanced Energy Association. The association has no witnesses today.
Thank you, sir. Staff. I thought we all knew staff. Staff, why don't you introduce yourselves?
Thank you, Mr. Can you hear me? No, this isn't working. Mr. Chairman, I'm Dawn Kelleher. I have with me Clay Layson, David Scott, and Eric Miller. Our 2 witnesses will be Mark Herring and Brian Seitz.
Thank you. That was on the second page of my script, okay? I hadn't gotten to that, but thank you. All those who intend to testify, will you stand and raise your right hand? Well, okay. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may be seated. Ms. Law, if you would give your opening statement by going to the lectern, that would be appreciated.
I'm not sure which mic I'm using here. Let's see here. This one?
Yes.
This one live? Okay, great. Okay.
Yeah.
Good morning, Chairman
Good morning.
Webb, Commissioner Anderson.
If you want to pull that other one down, that may give us double coverage there. Or
This one?
Yeah.
Okay.
Yeah.
This one's red. Should it be green?
Yeah, very good.
Okay. I'm not sure I want to be heard twice. That's going to be interesting. Okay. All right.
We've got 10 minutes, whether you're heard twice or not, okay?
Fair enough. Can I have 20 then?
No.
Okay. All right. Good morning. Entergy Arkansas appreciates the opportunity to present its first annual update for its rate schedule number 73, Generating Arkansas Jobs Act rider. The rider allows EAL to make certain investments in utility infrastructure by providing a streamlined, formulaic mechanism to recover on a timely basis the cost of commission-approved facilities not already included in rates. These investments ensure that EAL has adequate generation resources to support reliable service for our customers, which is a significant factor in enabling Arkansas to attract and serve growth opportunities. Strategic investments, as defined by Act 373, include projects that support economic development, enhanced reliability, and the transition to new energy technologies that benefit the state of Arkansas. In this first annual update, EAL has 3 resources: Ironwood, Jefferson Power Station, and Arkansas Cypress Solar and Battery. The Commission found all of these resources to be in the public interest and eligible for recovery through the rider. EAL appreciates the review by general staff and the AG of its annual update. With the exception of the issues discussed below, both the AG and staff found EAL's annual update to be consistent with Act 373 and the rider. Accordingly, the parties set forth two stipulations that have been presented to the Commission. First, EAL's update inadvertently utilized the rate of return on rate base that was included in EAL's Rate Schedule Number 44 Formula Rate Plan 2025 Evaluation Report, rather than the approved compliance filing rate of return filed on December 16, 2025. Matt Morey's rebuttal testimony acknowledged that EAL will update the return on rate base in its compliance filing for the annual update. This update to the rate of return will lower the overall revenue requirement by approximately $460,000. Second, the parties stipulated that the two issues that the Commission directed be briefed under Order Number 4 are ready for the Commission to decide based on the filed pleadings. With respect to those two issues, EAL respectfully submits that its initial and reply brief demonstrate how the plain and unambiguous language of the statutes and rider fully address that the Commission is the entity authorized to determine any deficiencies and to issue an order within 90 days of an annual update, and that there are no provisions authorizing the alternative approach advocated by staff. The joint issues list identified only two disputed items. With respect to the first disputed issue regarding whether inclusion of Ironwood in the annual update is appropriate, there is no legal or factual basis for excluding Ironwood from the revenue requirement. To begin, no party disputes that Ironwood meets the definition of a strategic investment as defined in Arkansas Code Annotated 2034-1303-10A. There is nothing ambiguous in the definition that would call into question whether Ironwood meets that definition, nor has any party made such an argument. In fact, in approving Ironwood's CECPN, the Commission found that EAL established the need for Ironwood to support existing customers and economic growth, that the resource would maintain and improve the provision of reliable electric utility service, and that as a dispatchable resource, Ironwood would ensure EAL maintained an adequate resource adequacy position within MISO. Even staff witness Mr. Herring agreed that all three of the resources, including Ironwood, meet at least one of the approval criteria. He also confirmed that should the Commission find that Ironwood is a strategic investment, staff would not object to Ironwood's inclusion in this annual update. It is also critical to consider that Ironwood fully satisfies the specific requirements under 23-4-1304W for strategic investments for which an application for approval was pending before the Commission as of March 20th, 2025. Importantly, Arkansas Code Annotated 23-4-1304-F1 provides, at the election of the investor-owned electric utility, strategic investments shall be recovered through the rider. EAL complied with this requirement when it provided notice to the Commission of its intent to include Ironwood in the rider in docket 25049TF and with its letter to the Commission in docket 24072U. Indeed, the Commission acknowledged the election in docket 25049TF when it ordered EAL to provide bill impacts under the rider to include Ironwood. Despite the clear and unambiguous statutory language I just identified and the undisputed facts of EAL's election and the Commission's acknowledgement of that election, staff nevertheless contends that Act 373 contains an additional requirement for the Commission to make an advanced determination that a resource is a strategic investment. This view is apparently based on the mere fact that there is a definition of a strategic investment set forth in the law. To be clear, there is no language to this effect contained anywhere in the statutes applicable to a resource like Ironwood, and staff cites to none. The mere existence of a definition in the law is similar to the fact that the law defines certain facilities as major utility facilities. Yet no party in EAL's dockets has ever argued that the Commission must first issue an order declaring that a facility meets the definition of a major utility facility before the utility can file for a CCPN. The fact that strategic investments are defined in the law is no different, and staff's attempt to read an additional requirement into the law is particularly unnecessary here, where it is undisputed that Ironwood is a facility with a capacity of 100 megawatts or more, and the Commission has already addressed that all of the criteria for a strategic investment have been met. There is simply no basis, legally or factually, to support staff's attempt to exclude Ironwood from the revenue requirement, which could have material detrimental downstream effects. Turning now to the second disputed issue regarding Mr. Meyer's position that EAL should acquire additional short-term debt to finance its long-term generation plants. Procedurally, an annual update is not the appropriate forum to adjust EAL's financing of project cost. An annual update is a verification that the amounts reflect the amounts authorized for recovery under Act 373. More substantively, Act 373 and the rider specify the rate of return to be utilized in an annual update. EAL and staff both agree on this rate of return. It bears considering that Mr. Meyer's proposal is also not reasonable as a practical matter. Financing billions of dollars of long-term generation plants with short-term debt, even if it were possible to acquire that much short-term debt, would lead to unnecessary risk for EAL's customers and potential volatility in rates. Additionally, EAL is subject to FERC financing limits. It does not appear to EAL that Mr. Meyer considered these factors or the provisions of 23-4-1304 M1 regarding the appropriate capital structure during construction under the rider. EAL is also prepared today to respond to the Commission's questions in order number 5. Mr. Clutcher can address the all-sector rates and how they remain well below 10% less than the national average EIA data, and Mr. Morey can address how the company's cost of debt is consistent with Arkansas Code Annotated 23-4-1304 M1D. When the record evidence is viewed in its entirety, EAL submits that EAL's proposed annual update is reasonable and satisfies the requirements of Act 373 and the rider. EAL respectfully requests that its annual update be approved for rates effective with the June billing cycle. Mr. Morey, Mr. Clutcher, and Mr. Palmer are available to address questions that the Commission may have. Thank you.
Thank you. Ms. Chandler or Mr. Lewis?
Good morning. On behalf of the Attorney General's Office, I want to thank you for this opportunity to address you all. As always, we appreciate the Commission's attention to this matter and its commitment to balancing utility needs with the interests of the public. As our expert Greg Meyer stated in his prepared testimony, the Attorney General's primary concern with Energy's annual update filing is with the minimal amount of short-term debt to finance over $1 billion in construction work in progress. This concern goes directly to the bills paid each month by families and small businesses. Short-term debt is the lowest cost form of financing available to Energy, and there is a responsibility to ratepayers that rates charged under the Gaja rider are truly just and reasonable. To be clear, Mr. Meyer does not challenge the cost of debt or equity set in Energy's most recent filing, but that using an assumed de minimis short-term debt balance that excludes CWIP from rate base does not reflect reality. There should be a reliance on an actual realistic capital structure. Each additional dollar of unnecessary financing cost ultimately shows up on a ratepayer's bill. A more balanced, reasonable use of short-term debt could save ratepayers hundreds of thousands of dollars, money that matters to households and small businesses already struggling in today's economy. Short-term debt is routinely and prudently used to bridge construction financing, particularly because CWIP is temporary and transitional. Interest rate risk is something utilities should be well equipped to manage through established financial tools and diversified portfolios. It should not be used as a justification for defaulting to the most expensive option available. At the heart of this case and all the upcoming Gaja Riders cases is fairness. Companies are often about spreadsheets, projections, and profits. It's also about families heating and cooling a home, small businesses struggling to stay open, fixed income grandparents, single income homes, ratepayers paying their fair share and then some. Utilities are granted a monopoly and opportunity to earn reasonable returns, but in exchange, ratepayers should not be asked to bear inflated financing costs rooted in assumptions that depart from real-world practices. Even modest protections can make a meaningful difference. Ratepayers are asking that this commission not view these projects, the financing of these projects, with blinders, but view these requests as building one on top of another. This Gaja Rider contains only 3 of Entergy's projects. There are more to come. Here today, you're presented with 3 projects that present, as they would portray it, only an increase of $5.77, a change of approximately 4.17%. Only a $5.77 increase to already high bills. Only possibly a gallon of milk and a dozen eggs that a family must consider using this money for. What about the next one that covers even more strategic investments coming? Eventually, it will not just be some ingredients for a meal, a partial meal, it will eventually become a whole meal families have to consider. We understand that there's a balance between reliable infrastructure and reasonable rates, but we've not reached that yet. All utilities, including Entergy, should consider short-term debt. When rates rise unnecessarily, trust erodes, and the ratepayers this commission is charged to protect pay the price. Mr. Morey's rebuttal testimony is simply wrong and misplaced. Unfortunately, due to the truncated timeline, Greg Meyer was never provided an opportunity to set out why and how to protect the ratepayers through fairness, but we have him here today. He's here to answer your questions regarding how to protect ratepayers and to maintain trust in the system while using short-term debt to support infrastructure. Thank you.
Thank you. Ms. Kelleher, you're recognized.
Good morning, Mr. Chairman, Commissioners Tate and Anderson. As I stated earlier, my name is Dawn Kelleher, and I represent the general staff in this matter. Today, staff will be presenting witnesses Mark Herring and Brian Seitz for the first of many annual updates filed pursuant to the Generating Jobs Act of 2025, or GOTCHA. Staff would like to thank all the parties for their cooperation as we work our way through the implementation of this new act. Staff appreciates the professionalism and courtesy shown by all parties. To begin, Entergy's Gacha Rider was approved in docket number 25049 TF as a novel rate recovery mechanism. The Gacha Rider provides a vehicle for Entergy to recover costs associated with construction projects from ratepayers using a rate based on a revenue requirement. On March 6, 2026, Entergy made its initial annual update filing in this docket. Staff reviewed the filing to verify the revenue requirement amounts and ascertain whether the filing complied with the GOTCHA provisions, the Gacha Rider protocols, and the Commission's rules of practice and procedure. Staff found the filings were deficient and filed its notice of deficiencies. In its cover letter transmitting its response to the deficiencies, Entergy denied that the items were deficiencies, but otherwise did not file a formal objection. On the same date that staff filed its notice of deficiencies, Order number 3 was issued scheduling the evidentiary hearing in this matter, which was later continued by the Commission order from April 28th to today. The hearing date contemplated that the statutory deadline for compliance began with Entergy's initial filing. However, staff respectfully disagrees. In its motion to adopt the procedural schedule, staff argued that the annual update should not be considered complete and the applicable statutory timeframe under GOTCHA did not begin until after staff filed its statement of compliance. This position was consistent with Order number 11 in docket number 25049 TF, which was the docket establishing Entergy's Gacha Rider. Order number 4 adopted the alternative schedule proposed by staff but did not include a reasoned analysis supporting the deviation from the Commission's findings in Order number 11. As a result, staff filed a motion for reconsideration of order number 4, which has not yet been ruled on by the commission. Order number 4 also directed the parties to brief legal issues, which the parties have done. However, if the commissioners have any questions regarding those legal arguments, I'm available to answer them today. The other issue staff identified was Entergy's use of the rate of return on rate base that was included in Entergy's Formula Rate Plan Rider Initial Evaluation Report filed in 2025, rather than the approved compliance filings rate of return. However, as stipulated, Entergy acknowledges the error and plans on updating the rate of return on rate base in its compliance filing and in response to order number 5. As Ms. Law previously indicated in her opening statement, Entergy included 3 facilities for recovery in its annual update: the Ironwood Combustible Turbine, the Jefferson Power Station, and the Arkansas Cypress Solar and Battery Facility. The Commission has found that Jefferson and Cypress Solar are strategic investment for gotcha purposes and approved associated cost recovery through the gotcha rider. However, Ironwood lacks such a finding from the Commission. In its testimony, staff argues that Ironwood should be excluded from recovery in the gotcha rider until the Commission determines that Ironwood is a strategic investment and a method of cost recovery is approved. In his testimony, witness David Palmer argues, in essence, that there is no requirement in gotcha for the Commission to make a specific finding that a facility qualifies as a strategic investment before it may be included for recovery in an annual update. This is clearly inconsistent with gotcha, as staff has stated in its briefs. While staff truly has the greatest respect for Mr. Palmer, he is not an attorney. Neither is Mr. Herring. If the Commission has any questions about this legal issue, staff recommends that the Commission should require either briefs be filed on the issue or ask questions of the attorneys present today. Thank you.
Thank you. Ms. McQueen and Mr. DePippa, since you have offered no witnesses and have taken no position, you will not be allowed to give an opening statement or cross-examination, as you know. But we appreciate your being here today. Are there any public comments?
Chairman,
Yes.
if I may, I'd like to make a motion to proffer an opening for purposes of appeal. And I would offer, of course, Mr. DePippa the same, as that's parties' rights under the law.
I will allow that
Thank you.
for the purposes of appeal.
Yes,
Okay.
this is a proffer of an opening based upon your ruling regarding the role of parties.
I understand.
In this
Understand.
kind of proceeding. I will be brief, and I understand that this is at your discretion, and I appreciate that. Basically, we're here to try to understand what is the role of all of this. The role of the government as reviewers, the role of a public utility, which is basically a corporation on government welfare. Sorry, don't mean to be inflammatory, but let's just call it like it is right now. We're private dollars. We are here to help to make sure, we hope, that the government and the public utility, they've done y'all's jobs. We're ready to be there if we don't think there is. Dollars can be put back in if we need to. But to require upfront a private party to invest, to put dollars in for witnesses, which are extremely expensive in something like this, when, for the purposes of this kind of case, perhaps what's more important is the process, the role of the parties, the role of the monopoly, the role of the process to make sure that all parties are heard for whatever they get to say, right? So, to require a private industry to have to put in dollars up front, I'm going to need an order, maybe a regulation, perhaps a statute, but you will need to decide that, because that's basically what you're saying. If you don't put down your billfold right here on this part of my process, I'm not going to let you participate. I don't think you have that discretion. So we're proffering right now the opportunity that if I'm a party for all purposes unless it's otherwise been limited. And I don't have to put in the dollars for witnesses, especially when my tax dollars are paying for witnesses right now. All of ours are, both ratepayers right now. This all comes back on us. So my position is that we have a right to be here, even if we say nothing. And we decide later whether we think that it met all the requirements of the law. That is our right as persons under the law, as both associations and corporations as our members. But what we do have besides that, a question of completeness of an application. This is an issue that's going to come up in other matters of equal importance, if not more. When do the timelines run in this state against a public monopoly? Do they run to the benefit of the public monopoly and the reviewing government agencies? Or do they run to the benefit of the people, the parties that are here before you trying to make sure it stays on track, even if it means it's just to say, excellent work, excellent work. And we only have this little bit of concern. That's what we're here for, we think. Not to carry the whole load. We already carry the load on the back end. Okay? So, we hope that the briefing that was done, there was no reason for us to brief additionally. There are so many words been put to the question of precedent. You've already decided whether an application is complete or not. And if the statute thinks it's complete when you first file, then every application should have the idea that you put the minimum part in, and only after later, when you, the regulated entity, thinks it's going to be good enough, you get to decide. That's not their choice. That's the staff, and yours if you agree. Also, who parties are, not your choice. That's your decision. So the idea on the joint list, not be included, finding parties for this, that's inappropriate, and it's a usurpation. And so all of this is about everybody getting back into swim lanes to a certain degree, and particularly the regulated monopoly. So the question is, did they properly tee up all three facilities? Doesn't look like it. Well, why should we give them the benefit of the doubt? They need to be on especially the first annual. Every single step needs to be right. Because every time you give them a squish, even if it means you got to work weekends, guys, you're going to have to make a decision in 2 weeks, 3 weeks, whatever it is. That's what you need on the back end, because otherwise it looks like you cut the time for the companies that are on the public dole and for the government. So I'm not trying to be inflammatory. I'm trying to say that on this side of things, we're a party, we want to be included, but we don't think it's our obligation to have to pay for it. We pay for it on the back end. We hope you will exclude Ironwood and require them to jump through every hoop, because they aren't the first, this isn't the first. We ask you to make sure that they've got all their rate of returns properly where they're supposed to be in order. Don't know that we've got that just yet, right? We have to understand whether this is the cheapest cost to the customers. And from what we see, the debt structure, it is not. So we've got timelines, process, the role of parties, the role of the government. It's an exciting case. But I think the first thing you got to decide is, do they have an application that this is the right time to be making all these decisions, and have you prevented parties from participating? Because in the end, that's what a court's going to care about. So,
Ms.
Thank you for
McQueen,
your
state
time.
for the record who you represent,
I'm
please.
sorry. As I represent Arkansas Electric Energy Consumers and their 14 members that are included in most Exhibit A's of our interventions.
Thank you for your proffered opening. Mr. DePippa, do you wish to make a proffered opening?
Yes, Commissioner.
You may proceed.
Thank you, Chairman Webb and Commissioners. My name is Joel DePippa, representing the Arkansas Advanced Energy Association. We recognize the leniency in offering this proffer for the potential of appeal, and do acknowledge that we are not presenting witnesses, but by order of the Commission are parties to this matter by being parties in previous EAL dockets. Specifically, we have briefed and have a substantial interest in the legal issues behind Order Number 4 that are as of yet unresolved. These go to, as Ms. McQueen has noted, not only this Gaja rider filing as the first for Entergy, but the first period, and potentially sets a precedent for every investor-owned utility for every year going forward. That is our interest, and what we have noted in our briefing, which I will briefly summarize for the purpose of the proffer, is that the plain and ordinary language of Gaja itself does not grant additional leniency to a private entity to make those determinations. In fact, under Gaja, specifically 23-4-1302-15 charges this commission with the mandatory language that you, quote, shall ensure that generation resources will maintain or improve the affordability, adequacy, and reliability of the grid. That is why you retain the authority to make those determinations, and as noted in the previous docket 25049 TF, you specifically granted non-discretionary authority to staff to determine deficiencies, similar to Rules of Practice and Procedure 811, previously 811, now 26 CAR 462, 811. The second issue that was briefed under order number 4, whether or not something is cured cannot be put in the hands of the individual who filed it. That creates a perverse incentive for any investor-owned utility to file something insufficient and deficient, file what they consider to be a cure, however, that is not yet communicated to other parties for, under the Commission's rules, a week, further shortening this truncated timeline. Whether or not all investor-owned utilities would do that is not the question. The question is whether or not that could be allowed. This commission has the authority and, in fact, has always been described as having a duty under 23.2.201 to ensure that the utilities are appropriately regulated for just and reasonable prices and to ensure that all parties have an appropriate say. I mentioned earlier that I represent the Advanced Energy Association. We have previously entered into the record of the commission our association bylaws. We have provided a list of over 100 members who are involved not only in the consumption of energy, but in the production of technologies, in their application, in their uses. Every single year, you're going to have more than one of these filings. This is your opportunity to ensure, as Chairman Webb noted, when you set sail today, that you set sail in the correct direction, not just for an utility, but for the commission, for the consumers, and for every other party involved. Thank you.
Thank you, Mr. DePippa. Were there any requested? There were no requested public comments. Is there anyone in the room that wishes to make a public comment for the record? Thank you.
Chairman, are you intending to address the legal issues first?
I'm going to do that right after we do, see if there's any procedural matters. Then I will do that.
Okay.
Yes.
I would like an opportunity to ask Ms. McQueen a few questions before we move on to those legal issues. So whenever you find that appropriate.
Let's see if there's anything procedural, then I'll go to you at that point.
Okay.
Okay? Are there any procedural matters that need to be brought up by the parties? Seeing none and hearing none, Mr. Tate, you are recognized for your questions to Ms. McQueen. Ms. McQueen, if you would come to the lectern, please. Anytime you wish to speak, come to the lectern. It just picks up the sound better, okay? Remember, eat the mic.
It's easier to do from a standing position.
Yes, ma'am.
Good morning, Ms. McQueen. You made some statements in your proffered opening that I want to get some clarity on. You suggested you were somehow prevented from participating, and I'm not clear how.
This is a proffer in response to the chairman's decision not to allow us to have an opening formally.
So that's all you're referring to is not being allowed an opening?
As far as I understood the ruling, that would be the only thing we would be prevented from.
Right. So you had an opportunity to file testimony or have a witness on your behalf file testimony, and nothing was filed. Is that right?
No, that's correct. We chose not to file a witness in this matter.
Okay. But you weren't prohibited from doing that.
No.
Okay. And you had an opportunity to file legal briefs on the issue that you raised, and you didn't do that either, right?
We chose not to incur those private dollars when we could see that the public dollars were doing such a good job at it already. And it's
Right.
a rather simple issue. So yes, we chose not to file legal briefs because I don't think we're obligated to do so in that regard.
You're not obligated, but you made the statement that you've been prohibited from participating, and I want to be clear that that's limited to the issue of an opening statement. You've had opportunities to
If you
participate.
concur that it's limited to an opening statement, then I take your word for it as well, sir.
Well, all the other deadlines for you to participate have passed, and you haven't participated.
This is the hearing in the matter, sir. There's many
Yes.
opportunities to participate thereafter, including reviews of your order and reviews to a court of your order. Like, this is the beginning of a process in most cases, the hearing. I know we do pre-filed in this case, and it makes sense with the kind of dense, accounting work that you do, so there's plenty of timelines. But I don't think there's anything in the statutes, the Constitution, or your regs that require people, and if they are, then it needs to be clear, because this is the problem. is what's expected of us. Are we expected to put actual witnesses? Because those are 6 figures often, even in a case like this. So, again, I don't think we're obligated to do that. We're obligated to participate. We're here. We're here with the witnesses of the monopoly, the witnesses of the government council, the witnesses of the attorney general, however else we feel like we can participate and help out. And then on the back end, we're there to decide whether there needs to be additional briefing and additional appeal, right? All parties, it's a community effort in some regard. So if there's a rule that we have to be doing these other things, I think we got to make it a rule, or there's got to be a clear order of the commission for the purposes of appeal thereof.
This isn't about what you're obligated to do. You've been allowed in as a party, and the first time you voiced an opinion about anything in this docket is today in your proffered opening. Can you point me to something you filed where you voiced an opinion?
Am I required to file an opinion before
Again,
the
you're
hearing?
turning it around.
No,
This
I'm
is not
not.
what you're required to do. You're saying you were not allowed to participate, and I'm failing to see up till today with no opening where you've been not allowed to participate.
We said we would participate in the hearing and responded to the request on the information sheet that we would be here. So then we were told we would not be able to give openings. There was no motion. I'll make an additional objection to the fact that that was a ruling made without a motion of the parties and on the sua sponte order of the commission, which we appeal, at least in this regard, to you to reconsider, because we weren't given the opportunity to address that except right here, right now. So in that regard, we were prohibited. We were not included in the issues list. We weren't contacted about it. We could have contacted others, right? But it's also an issue about process. PSC process that's been going on for a lot of years about who decides what parties are, what do they get to do, who decides on issues lists. And again, that's the objection in part we're making. So we didn't participate on specific legal briefs because there was no need. You have plenty in front of you to decide that issue. That wasn't my duty. My duty also wasn't to file witnesses when we believe you have plenty of witnesses for which to make a decision upon which we support, which is to turn it back. So and from where I'm sitting, part of our job is just, again, make sure that everybody who's otherwise not a customer is here. So we chose how we participated, and I believe that's our right. If you believe otherwise, then we ask for a ruling of the commission that's clear, supported. And again, because our options after that are appeal. That's just the law. Nobody needs to get their feelings hurt. We're trying to work out a process for a long-term precedent and a lot of money. And we're the ones that carry a huge, if not the biggest chunk of it. So yeah, we care about what's expected of us on the front end, and we care about what's expected of us on the back end. And we chose to participate the way we have right now. And I think that's our right.
All right. Thank you, Ms. McQueen.
Let us be clear, you were not allowed to do an opening statement or to cross-examine witnesses, since you did not offer witnesses on your own. That's the ruling of the chair. Okay? I want to be clear about that. You may object to that, but that's the ruling of the chair. I'll give you 1 minute.
Yeah, and then we just lodge our objection to that ruling of the chair. Thank you.
That's fine.
And we
So
can-
noted. You may be seated. The commission has some legal questions to the attorneys. And Ms. Law, you're going to be the first one up if you'll take. Since this is a case of first impression and we're all of understanding, and it has great ramifications long term. How is a deficiency in statutory completeness of an application different from a deficiency under a tariff?
Sure. So,
And I'm going to give each person the opportunity to answer that question, okay? Yes.
Sure. So I think it depends on the tariff, right, and how it's outlined, but I'll start with that. I think that if there are things in a tariff that are not presented that are required, for example, filing requirements, right? And there's a process in a tariff that outlines where staff or another party can identify that that information wasn't provided and it is inhibiting their ability. I think the commission's rules even say that, inhibiting their ability to review the filing, right? then they can certainly raise that and it can be cured. So, for example, here, had we completely forgotten 3 of the filing requirements, didn't provide them at all, that would be raised. That is, to me, completely separate than a statutory requirement. Statutes can't be altered by a tariff, they can't be waived by a tariff, they can't be waived by the parties, right? The statute is what it is. Our statute here sets forth a specific time frame that an annual update from a party is to be ruled on. So here, if an annual update is filed on a date, the commission had 90 days to issue an order. It even outlines in that statute what the commission should do and include in its order should it find that the application didn't meet the statutory criteria and how that would unfold. There would be no reason to include any of those provisions in a statute if a party in a docket could merely raise that something was not included in initial filing and then none of the time frames start. It's very similar to how we handle a rate case, for example. Rate cases, the law says that you can only waive that up to 9 months beyond that initial 30-day period, right? And that you have to rule on it or it otherwise goes into effect. When deficiencies or anything happens within a rate case, it all stays still within that procedural schedule regardless, because that is the statutory time frame, because the legislature has found that that is necessary to make sure that whatever it is that is being proposed or proffered needs to be ruled on in that time period and doesn't go on forever. And so I think they're different in that one is where in a rider there is an adjustment to the procedural schedule within the statutory timeframes to make sure that all the information is out there and that the parties have it, versus an actual statutory deadline that says this is how we're going to handle the whole case.
If Entergy files an application, excuse me, with deficiencies under a tariff, the staff is granted additional time to file its direct. Should an additional time come out of Entergy's time allotted for rebuttal?
So I think it depends on the time frame and how that works. I think the intent was that everything in this particular rider would shift and still be achievable within the 90 days. I think where it does not, then the time frames in the tariff would have to be adjusted, because we can't adjust the time frames in the statute. They are what they are. But I don't, Entergy in this instance and in most instances would be the party that bears the burden of proof. And so there still has to be a fair and reasonable amount of time for response. And so I don't think that the tariff should adjust it to the point where there is no time for a response, right? I think there's got to be a fair and reasonable balance if the original deadlines in the tariff can't be applied for some reason. I would hope the intent, though, within most tariffs is that they would be already set forth in such a way that they would adjust and still fit within the statutory time frame.
Is there a difference between a statutory and a tariff deficiency?
I think that there is.
What is the difference?
To me, the difference is under a statutory, in this instance, I'll use this statute for example. This statute outlines what a party has to do when it files an annual update and what has to be included in that, and then what is to be reviewed. In fact, it's supposed to be a review of, did you put the numbers into the formulas according to what the law says we're supposed to calculate for CWIP? Did we put the numbers in for the rate of return that we were supposed to use, et cetera? Like, how does that all work? And that is the statutory piece of it. Separately, the parties negotiated and then presented to you all, and you all added to what you would like to see presented with an annual update to help everybody understand that. Those are filing requirements. And to me, that is very different, that those are required under a tariff to help parties review items, but they may not be required by a statute to actually comply with what is required for an annual update.
I'm of the opinion that not all deficiencies are created equally. Okay? There are some deficiencies that could be detrimental for failure to include the information. There could be deficiencies that are not of great loss. Okay? What occurs if I think a severe deficiency, just my opinion, is there is a statutory date in which the annual review is to be filed. Correct? And that date is chosen by the IOU that initiates the annual review. Okay? What occurs when the IOU doesn't file a complete report on the date that it is due under statutory law? We have a deficiency that is required by statute. We have a date for filing that is required by statute. What occurs if that deficiency is not cured by the deadline date?
So first, I think I would say that the law said that the utility elects that date and it's included in within the tariff, right?
That's correct.
So I think that the date itself is something within the tariff, which could be adjusted depending upon, for instance, something like
But
a deadline.
the date is required to be chosen under statutory law.
Correct. And I think if it's chosen and included in the tariff, though, that doesn't mean that the date could not be adjusted within the tariff. It was chosen when the filing was made. In other words, you have to elect one and include something, but tariff provisions can certainly be adjusted and waived, and we have schedules that do that
You know,
quite frequently.
one of our concern with this statute is the timelines that are imposed on an agency that needs more staffing, to say the least. And when a incomplete update is filed, it limits the time that the response is to be made, and this commission has to make an order. Okay? And review could not begin until the deficiencies are filed. Okay? At what time, at what point, how late in the process can a deficiency be filed and still be accounted as a complete annual update? How late could that filing occur?
If we're talking about
That could be left to us, but I'm seeking your advice.
Sure. If we're talking about within the statute, I think the statute lays that out. So I think there is, we'll just hypothetically say, because we don't agree here, right, that these were deficiencies. We filed everything we think we were required to file under the tariff and the law. But hypothetically, if something was truly deficient and the filing could not be analyzed, you as a commission could not determine what revenue requirement we were doing, right? I think there is exactly where the statutory provision comes in that says that you would issue an order and you would indicate what it was that was deficient by the utility. And then we have a period of time to cure that deficiency under the law. And then there is a period of time to issue another order. It lays that process out. And I think that is for you to determine if our filing was not compliant with Act 373 and
And
its
what would the
requirements.
penalty be if we determine that it's not compliant?
Then
What penalty could we impose?
I'm not sure that the law calls for a punitive penalty, if that's the question. I think that the law sets forth a process for what happens in the event that you identify that.
For example, and I'll seek your thought on this. It is a deficiency. It's not punitive, but it wasn't filed timely. What if we denied the CWIP for the year until the next annual report because it was not filed on time?
So respectfully, I don't think that the law would permit that. I think the law would say that you would have 90 days to issue an order stating that was your deficiency. And then, of course, we would have an opportunity to cure, which I think with your timeline is where you're saying is perhaps there's a concern. But again, I think that was the date, the specific date is what was elected in the tariff. I think the objective was to elect a date, not to set a statutory date on that.
So how do we compel compliance with the rules and the law? How can we encourage, and I'm not speaking necessarily to energy, I'm thinking of all IOUs. What if someone waits to cure their deficiency to 45 days into the process? What can we do about that?
Well, so I think first there are the tariff provisions, right, that indicate when it should be cured, which tolls certain of the timelines within the procedural schedule. But I think your ultimate remedy is within the law, which is to issue an order within the 90-day time frame that says that there is a deficiency. And I think it specifies what those findings are that you would put in your order. And then the utility has an opportunity to cure, and then the review period starts again under the statute.
Thank you for your answers. Does the AG have any response to any of those questions? I'm not going to repose the questions, but we're seeking your wisdom. Okay?
Chairman, if,
Thank you.
if Commissioner Anderson or I also have questions related to this,
Yes.
are we bringing the attorneys back up, or should we address those with the attorney before moving on?
Let's do that. If you have questions, let's have Ms. Laws come
Okay.
back up.
Okay,
Let's do it attorney by attorney.
okay.
Okay? Yes. Ms. Law? Sorry, I apologize.
I needed some extra exercise.
Mr. Tate, you have a
Am I
question?
going?
Yes.
I've got the mic? All
Yes.
right. You drew a distinction between a statutory deficiency and a deficiency per the tariff. Can you give me an example of what would be a deficiency under the statute for purposes of this filing?
Sure. Well, let's say that we provided all the information and we've miscalculated something under the tariff. I mean, under the statute, right? And we didn't cure it beforehand, right? When staff perhaps identified it. And so you all were set to rule on it, and we didn't calculate it consistent with what Act 373 does. You wouldn't have to approve it with a miscalculated, say, CWIP in there. You could identify that it doesn't meet the statutory definition of what was required for that. And then we would be, I think it's 10 days here, able to cure that.
So the only difference then is whether that's grounds for us to deny the application, and it's Entergy's position that a deficiency under the tariff is not grounds to deny an application?
I think it depends on what the deficiency is, right? Several of our filing requirements are embedded within what's required in the law. I think there are other items that are filing requirements and information that is provided to help the parties review. But I don't think that under Act 373 would qualify as something that would deny an application, no.
So the requirements under the tariff, you're suggesting that if Entergy made a filing and didn't comply with certain aspects of the tariff and never cured those tariff deficiencies, we don't have a choice but to approve, or that's not grounds to disapprove the filing by Entergy?
I think it really depends on what they are, right, and the magnitude of them. I mean, if there's truly something not provided that's preventing a review, then I certainly think that would be within your purview. But ultimately, we're required to comply. I mean, this statute, maybe unlike some others, is very specific as to what is required and what will be reviewed in an annual update. And so, I do think that that lays forth the process for identifying statutory deficiencies.
So how do we handle then tariff deficiencies?
I think that's where the process that was identified in the tariff for staff to raise those and us to have an opportunity to address those before it ever gets to that point. I mean, that was the purpose of that.
And if those are never remedied, there's not a remedy. If Entergy never fixes those deficiencies that are purely tariff deficiencies, there's not a remedy for that.
To the extent that they don't impact what is ultimately required to be approved under Act 373, then I'm not sure how they would be.
And who makes that decision?
I think that you do.
Okay. Entergy's not contesting that what was initially filed didn't meet the requirements under the tariff. I understand you're suggesting it's not a deficiency, but you agree that what was filed, we'll refer to the Excel spreadsheet. Links were broken. They weren't fully functioning.
So
Do you disagree with staff's assertion of those Excel spreadsheets not meeting those requirements?
So I think that they had a couple of items. So if I could take them one at a time,
Sure.
I think one was that the Excels weren't filed in the docket. They were provided to the parties and they were functioning, but they weren't uploaded. And that was an inadvertent error that we corrected, right? So that was one piece of it. I think the second piece was they were asking for additional information that wasn't a part of the original filing requirements, and so not something that we would have known that they wanted or needed to review. And I think that's where we don't agree that that's a deficiency. That wasn't a filing requirement or an item that we needed. But we were willing to provide it and to keep the docket moving on the timeframes, did so, 2 days after they identified that.
You've laid out what you think the statutory process is for statutory deficiencies. When, in your mind, does the commission determine whether it's deficient or not?
I think you have up until 90 days. I think you could certainly do so earlier than that. I think, was it order number 4, in a footnote recognized that should there have been statutory deficiencies that needed to be recognized earlier, that they could have been. I think you would have the option to do that if you chose to do so.
But what is the consequence of doing that?
It, I think, then starts the time frames within the statute where
So
we
we
would
no
respond.
longer have a 90-day review period, we
right.
would have a 10-day review period.
Correct.
So I'm trying to understand from the other party's perspective how this process is fair. I'm not suggesting in this case that Entergy has done this, but what prevents a utility from filing a bare bones application that arguably doesn't meet the statutory requirements? The parties are required to do whatever analysis they can of that, and they won't get a determination from us until the 90-day mark whether it was deficient. And at that point, it triggers this 10-day review process. So in reality, they'll only have 10 days both to analyze your filing and for us to issue an order. I'm struggling trying to understand how that process can't be abused. Again, not suggesting that's what's happening here, but it seems to leave that door open for it.
Sure. So, one, I don't think that utilities would have an incentive to do that. As you can imagine, with the type of dollars we're talking about here, that implementing rates on a delayed basis, even where you're talking about you issue an order 90 days, somebody cures in 10, and we go forward, you're not talking about delaying that by a month, 2 months, 3 months, however long that cycle process takes. And with the dollars we're talking about here, that is a significant impact to these projects that are all on very tight timelines in order to meet the needs of our customers. So personally, I don't see that utilities would be incentivized to want to delay or risk not having an order timely for that. I mean, I think that was the purpose of Act 373 and is probably in the legislative findings that it's necessary to move these projects along in order to meet the pace that we are faced with customers these days. So I don't think utilities would be incentivized to do that. As a foundational matter, but really this mechanism was intended to be a math exercise, right? You have the underlying proceedings where these projects have all been thoroughly vetted. The law outlines mathematically what you are allowed to recover. The tariff has those filing requirements where those numbers are included. It shouldn't be an extensive review anyway of that. I mean, it is simply following the law, following the math, and putting the numbers in. And so I just don't see that utilities would have an incentive to want to delay, but I also don't know that that should be an impediment to being able to review it in those timeframes.
So the chairman touched on this a bit, I think. The statute allows you guys to elect the date on which you will do your annual filing, right? And then that date is incorporated in the tariff. I believe the tariff says on or about March 1st for the initial filing. I believe you guys filed on the 6th. Is that right?
Yes.
And then going forward on an annual basis, your filing is due on or before that date. So going forward, it would be due on or before March 6th. Is that your understanding?
I thought it was on or about, but
So
perhaps
it's on or about March 1st for your initial filing.
Mhm.
Subsequent filings are on or before the same date that the initial filing was made.
Okay.
What happens if you guys miss that date?
I really haven't thought about that question, if I'm honest. I would hope we would not miss that date. I mean, because it is, though, a date in a tariff, I do think that you have discretion to alter, waive, or amend those dates, just like other tariff provisions can be, as opposed to, again, I think the law required the utility to specify something to provide timelines to the commission in its tariff. I don't think that it was intended to be that it could never be modified.
So it's within our discretion to allow a late filing?
Correct.
And if we chose not to, then what? The utility would not get right of recovery for that year? Or would not get to make an annual update filing for that year?
I'm not sure what would happen in that circumstance, to be honest.
You're not suggesting that the utility can continue to modify the date it has elected for a filing, though, right?
No, I'm not suggesting that. I'm just suggesting that it is a date in a tariff, which, like other dates in tariffs, like the procedural schedule here, right, could be modified as opposed to a statutory time frame that cannot be.
So without pulling one of the parties' filings, I don't actually have the statute in front of me, but I believe the language of subsequent annual filings being honored before the initial date elected, I think that comes from statute. So subject to
Correct.
check.
I think you're
That's
correct about that, yes.
Not something then we could waive.
Well, I still think it's the date though, but I mean, I think to your point that if you've moved
Well-
forward with the if we filed March 6th
Right.
this year, right, we would have to file honor before that date going forward.
And that's not a date, if that is how the statute reads, then that's not a date that we could waive. So if you guys failed to make it by March 6th, that's not then something we could allow a late filing for.
I would agree.
Okay. I think that's all I have, Chairman. Thank you.
Ms. Anderson,
My questions have been answered. Thank you, Chairman.
Okay.
you may stand down for now. Mr. Coates? I'm going to step out just a minute. I've got to paint, but go ahead, proceed. I'm just going to be in the room. I can hear what's going on.
Hi, my name is Michael Coots. Thank you for this opportunity. I know these issues are really important. And so I have down, the first question is, I think the chairman indicated that maybe y'all won't repeat the questions and we can just keep going. How is the statutory deficiency different from a tariff deficiency? We think it's essentially the same. The tariff deficiency is nested within the statute. So the tariff was built within the statute's confines, and that's what we discussed deliberated in docket 25049 TF. So I think it comes down to that. So deficiencies, and they would need to be material deficiencies, but like here, they would be material in the process of review. So staff indicated in its notices of deficiencies that it couldn't properly review things, and that would be a material deficiency to basically, trigger both a tariff deficiency and a statutory deficiency. And then under the second question, so I have under the tariff, well, I kind of already answered it. I think it was what would kind of qualify as a deficiency, and I think it would need to be a material deficiency affecting the review. Because the commission, under the statute 1304E2D, the commission's job is to verify the amounts, and that's kind of the staff on the front end, as designed under the tariff, is charged with essentially making sure that the amounts, making sure that review can happen. So that's essentially for administrative efficiency. And I think under here, I think it's clear that, this is kind of the first one, the first annual update filing that we've had to deal with. And there's been a lot of issues that have come up. So I think it's good we're getting through it, but yeah, I think it comes down to administrative efficiency, and that's what staff's job is to do, to review. And then the third one, Chairman Webb asked whether about a severe deficiency. What if the IOU doesn't file a complete report? And I mean, essentially an incomplete report based on a material deficiency is not merely imperfect, it's incomplete. So it doesn't actually trigger the statutory deadline. That's because it's under 1304E2, the commission is charged with verifying the amounts and it can't conduct its review. And then the next question, review cannot begin until deficiencies are cured, then what penalty could the commission impose? I mean, the penalty is it would have to, like we've argued, push the deadline out, essentially. I mean, if there are any back end issues, because I know Entergy has talked about if the timing is pushed out, that there may be, budgeting mismatches, then those could be true upped. I mean, y'all would certainly be in your realm to be able to true up those issues, or maybe not allow the company to collect, if there were any deficiency, lagging timelines. The next one was, how do we compel compliance with the law? Along the same lines, I think it's about the minding the statutory deadlines, and if it has to be, pushed out because a filing was incomplete, then I mean it's not compliant with the statute. So I think the commission's required to do that. And then that's all the questions I had for Chairman Webb. Commissioner Tate, you asked how the process is fair and what prevents a utility to file a bare bones application. I think that's a concern staff, us, and AEA had. I think it creates a perverse incentive. It's not necessarily that it will happen, but I think it does create an incentive for them to potentially file an application that's incomplete. So I think that is a worry, and that's why, based on administrative efficiency, based on whether or not the application is complete, I think certainly the statute, I think General Assembly would have imagined a complete application being filed. And do y'all have any other questions for me?
Mr. Tate?
I wanted to clarify something. You seem to be analyzing this a bit different than maybe I was. You're suggesting, and feel free to correct me if I'm looking at this the wrong way, you seem to be suggesting we should be looking at whether the deficiency is material, not whether it's a deficiency per the requirements in the tariff versus the requirements in the statute. Is that correct?
Yes, well, and I guess, I mean, a deficiency in the sense that it would affect the review. And I think under the tariff, it more or less says that. I think the wording of the tariff, I don't have it in front of me, but this tariff is all about the commission's job for verifying the amounts within it. So I think any deficiency that affects the review, such as this case, would qualify as that. I mean, there might be some non-material deficiency, but I'm having a hard time coming up with something. But yeah, I mean, I think that it's all about kind of the review of it.
So this is more of a process question again, because the way the statute lays this out, it gets complicated. Who makes the determination that a deficiency is material?
That would be staff. Yes, sir.
Staff would make the determination whether it's material?
Yes, sir. Yeah, on the front end for administrative efficiency's sake, that's why it was set up in the tariff under 25 or 49 TF. it's my understanding that's kind of the normal process of things, to where it sets up the commission to, well, it sets up the parties to be able to review the complete application, and then we can all go forward from there and be able to argue like the numbers, verifying the numbers behind it.
Again, I don't want to put words in your mouth, but you seem to suggest the natural remedy to a deficiency would just be to push the deadline. Is that a fair assessment of your?
Yeah, I think under the tariff that if it is an insufficient application, if it's incomplete, then it would not trigger the deadline. So I guess not pushing it out past 90 days, it just wouldn't trigger the deadline on the front end.
So move the deadlines around within the 90 days.
Well, if there's, like we've argued in the legal brief, if there is a deficiency highlighted by staff where they can't conduct their review and the other parties can't, then that would not be, it would only trigger when it's cured.
I'm not clear what would only be triggered. Staff's deadline to file responses.
I apologize. The 90-day time frame and the 60-day.
So it would. So you are suggesting then it would move out that 90 days potentially until the deficiency is cured.
Yes, sir. Yeah.
So what I'm struggling with is how we can do that, given that the statutory language is we have 90 days to issue an order from their filing. Or are you suggesting, for purposes of the statute, a filing should be read as a complete filing?
Yes, sir. Yeah. Yeah. I think it's, I mean, strongly implied that it should be a complete filing. Basically, I mean, the time frame is really short, and I think that, like I said earlier, I mean, it's an incomplete filing if there is a deficiency, and that it wouldn't actually trigger the law. And there's something similar that happens with the Arkansas Court of Appeals and Arkansas Supreme Court, where a document is tendered, and if there is some sort of issue with the kind of the face of the document, that it doesn't actually trigger the timelines for the other parties. So I think this is very analogous here.
We'll have opportunities in the future to make adjustments to the tariff. This is our first kind of cycle through that. I'm sure we're going to identify issues. This seems to be one of the ones we're struggling with at the moment. In other type of dockets, other parties are permitted to file errors and objections or notices of deficiencies.
Mm-hmm.
In this docket, only staff is permitted to do so. Do you think that is something that should be considered in the future? Is other parties should have an opportunity to file notices of deficiency as well?
Yes, sir. I think that'd be fine. Yeah, I think that it from what my understanding is, the normal course of business is that staff does that. But yeah, I see nothing wrong with opening that up to other parties.
So given the shortened timeline, and what has been suggested is that the party filing the notice of objection is kind of making the determination, how would that work if a bunch of parties have the opportunity to do that? Would any one party then filing a notice push those deadlines out?
I see. Yeah. Yeah. Well, and I mean, it comes back to the tariff wording, and staff in this case is set up that way. I would think that we would probably need to, kind of figure out a separate process for that if we open it up to other parties. But I mean, I'm not necessarily recommending that, but I think it would be possible.
So you suggested that a filing that sets that 90-day deadline assumes a complete filing. So we talked before, or I asked Ms. Law the question about the deadline that they've elected, or the date they've elected, which is now a deadline for future filings. If they make a filing that is determined not to be complete by that deadline, what happens?
Well, so they would file it just like this case. They would file it, staff does their review, and it comes back as there are deficiencies and they're not able to conduct their review. It would fall on the company to cure it, and then staff needs to, basically rule that it's cured. And then from that point, that would trigger the deadline. So, if there are 20 or so days between the company filing the initial incomplete application, then and all that process happens, then the 90 days would start that 20 days after.
So the filing doesn't relate back it to the original filing, or does a new deadline begin?
Well, I think it's a new deadline. Basically, it doesn't trigger the statute, and that's kind of what we're arguing here is that there's just not enough time to review anything, and I think that the statute contemplates whether or not the application is complete.
So
And-
to be clear, you're saying that if a complete filing is not made, in this instance on March the 5th,
yes, sir.
and it's not completed until July the 7th, the 90 days begins running from July the 7th,
Yes, sir. Yeah.
because that's when it was completed.
Yes, sir.
Okay. So and to clarify, since you represent the Attorney General, that's the opinion of the Attorney General?
Yes, sir. Yeah, and our legal brief lays that out.
Okay, thank you.
Yes, sir.
Ms. Anderson? And I apologize, I suddenly had a severe pain in my back. Most of the time I'm a pain in somebody's butt, but this time I had a pain in my back. So that's the reason I'm moving around to try and get comfortable, okay? Any further questions here? You may stand down. Ms.
Thank y'all.
Ms. Kelleher?
Thank you, Mr. Chairman. I'm going to try to address the questions, but there were a lot of questions flying around, and so I may not have gotten to them all. So please, ask me questions if I don't get to them. The first question that I remember was whether it was addressing the tariff deficiencies, and I think in this case, we're not considering, as far as I know, who has control of the filing. The IOU has control of the filings. They have plenty of time prior to the filing to make sure that the application or the tariff is not deficient. They have opportunities to contact staff and see, preview their filing to make sure that the deficiencies were, any deficiency are addressed. In this case, and staff tried to work with Entergy. We don't file notices of deficiencies lightly. We tried to work with them to get the information prior to filing the notice of deficiency, but after we weren't able to get what we needed, we felt like we had no choice. As far as the materiality, that's a hard word for me to say, materiality argument. I think Ms. Law said that this type of tariff is a math exercise. Well, if you can't verify the math, what good is the application? As far as, I think there was a question by Commissioner Tate about whose job it is to review for deficiencies. Historically, that's always been staff's. And I believe it was order number 11, establishing Entergy's gotcha rider, the commission specifically instructed staff to review for deficiencies. So now, as far as opening it up to other parties, because historically staff has always reviewed for deficiencies, I'm not sure that it would be wise to open it up to other parties, because just like we're arguing that the IOUs may try to game the system by filing insufficient documents and having deficiencies. I think the other parties could also possibly game the system, which wouldn't be fair to the IOUs. If they file something and for some reason it's not deficient, but some other party says it is, I just don't think that's fair to anybody. I think deficiencies, determination of deficiencies should remain with staff. I think you asked about what is the penalty, whether you can push the deadlines out or whatever. I'm not sure that's included in the statute. What is included in the statute is the requirement to file or issue an order within 90 days of the initial application. The commission determines what the initial application is because it's not defined by statute. You have the opportunity to determine when an initial application is filed. And if it's incomplete, that doesn't meet the statute definition of initial filing. So staff's position is that when an initial filing is completed, the statement of compliance is filed, that's when the timeframes for the 90 days should begin. You also ask how to compel compliance with the law. The commission has very broad authority. It has very broad powers, and the Gotcha Act did not limit those powers. So I would propose that the commission can come up with other ways somehow of imposing penalties as they think are necessary. And I think that was all the questions that I wrote down. Do you have any others?
Ms. Anderson? Mr. Tate?
Good morning, Ms. Kelleher.
Good morning.
We'll start with something that you just mentioned. You said the commission gets to determine when their filing is an application.
Correct.
When do we make that determination?
When staff file, if in the case of a deficiency, when staff files its notice of compliance.
So walk me through that. How is the commission at that point making a determination whether what they filed is an application for purposes of the statute? By order?
As far as the rules of practice and procedure, an application is complete when the deficiencies are cured by a statement of compliance. So after the statement of compliance is filed.
But that's not the commission making that determination. That's the general staff making that determination.
Correct.
Okay, so it's not the commission determining that what they filed is an application or a complete application. If we want to use that, it's general staff making that determination.
Subject to the commission's approval. I mean, if the commission.
When are we approving that? Are we consenting to it by remaining silent? Is that this?
I believe that's what has happened in the past.
Yeah, this is a bit different though, and it's a separate statute with its own mechanisms. It seems to be what we're mostly struggling with, or what all of us seem to be struggling with, is just the shortened time frame. And how do we comply with the statutory requirements within that time frame, but also make sure the parties, staff included, have the information they need to evaluate the filing, right? The statute spells out a process if we make a determination that the application is insufficient. The problem being that it kicks it into this separate cycle where now we're on a 10-day deadline, not a 90-day deadline.
Right.
You suggested that their filing is not a filing unless we determine it's a filing. I'm curious when that happens. And we seem to be blurring the line between when the commission is making a determination and when general staff is making a determination.
Correct. I would posit that the interpretation that the commission, has to review each annual filing within 90 days. And if they don't make that decision within 90 days, then that whole 10-day process starts.
I'm not sure I agree. If we determine if we determine that their filing is not, does not comply with the statute, then that 10-day process applies.
Correct. But I think that the deficiencies and the start of the whole process is different than the process outlined for the commission to make a determination whether or not the filing complies with the statute, which is what it's required to do. Right? So it says the commission shall verify the amounts included in each annual update reflect the amounts authorized for recovery under the Generating Jobs Act of 2025. That's 23-4-1304E to D. So what makes an application a complete application is the deficiency argument. Whether or not the application, once it's complete and the clock starts ticking, the commission makes the determination at that point whether or not the application itself complies with the statute.
Are you envisioning a commission order at that point doing so? Again, otherwise all we have is staff's filing that it's complete or that they've been remedied, right, or cured.
Right. The deficient application, the party filing the deficient application has an opportunity to object to the deficiency notice. And if they don't, then I would assume that staff's notice of deficiencies is valid and that any kind of action after that is only going to be compliance with the application and a statement of compliance thereafter. Is that the
No,
commission?
we seem to still be blurring the lines between the commission gets to determine whether an application is complete, but there's not actually a commission determination that an application is complete. All that's on the record is staff's notice of deficiency and then any filing after that suggesting that those deficiencies have been cured. But if I'm understanding your argument, you're suggesting a commission determination that an application is not complete doesn't trigger that 10-day filing. That is something different, that their filing is not compliant with the statute.
Correct.
Okay. Do you draw a distinction between statutory deficiencies and tariff deficiencies?
No. The staff reviews deficiencies, reviews the application for deficiencies based on the statute and on the tariff.
And it's staff's position that regardless of the language in the statute, that once the application's filed, we have 90 days to do our review. We can push that deadline out based on when the deficiencies are cured.
I'm struggling with the phrasing because we're not pushing anything out. We're trying to determine when the starting point for the timeline to run begins. So it's, and staff's position is that it begins to run when the notice of compliance is filed and the deficiencies are cured.
Well, so let's take this one as our example. They made their initial filing on March 6th, right? So in
Correct.
future years, that is the date we talked about that their filing has to be on or before, right?
Correct.
So let's say they filed March 1st, but staff filed notices of deficiencies, and for purposes of your argument, the application isn't complete until end of March. Walk me through how that works as far as their recovery through the rider that year. Would rates still go in effect in June? Well, let's push it even farther out. Let's say that, based on your argument, our 90 days for an order goes past June, but those rates were supposed to be in effect in June. How does that work? Do they forego the months of recovery before the order's in effect? Do they recover the entire amount over fewer months? Does that period extend out now until the next year, so you potentially have pancaking of this year's recovery and next year's recovery?
I would say that, as I said earlier, Entergy or any IOU has control of when they file and what they file. They have the opportunity to come to staff and ask, preview their filing and see if there's any deficiencies. They are in control. And they file if they file an application that's deficient anyway, that's on them. The ratepayer should not be required to pay for any of their errors. It should be on the company.
But what does that look like? I mean, I appreciate your argument. They control the filing.
Mm-hmm.
But let's assume they made a deficient filing and those dates all get pushed. How does that work? I understand I think staff made the argument in their filing that ratepayers shouldn't be harmed. As a principle, I agree. How does that work? Do they not recover as much? Do they recover it over a shorter period? Are we saying that's not harming ratepayers? How does that? We're clearly not moving all those dates out for the rest of the period, like for future years, right? Because in the tariff we have set deadlines.
Correct.
So how does that work if we've got a shorter period 1 year and they're supposed to make a filing by a certain date the next year?
I'm not an analyst, so I don't know what the impacts would be. I will say though that any of those methods that you suggested are possible as long as they don't impact ratepayers.
But it will impact ratepayers one way or the other.
Not if Entergy is not allowed to recover for whatever months that were pushed back because of the deficient filing.
So now you're talking about just months they don't get to recover of the rider because of when they filed. But you're not suggesting those amounts are not recoverable at all. They're just now not recoverable through the rider, right? All of this still affects ratepayers.
Correct.
It's staff's position that's not a negative effect to ratepayers or future ratepayers.
The gotcha rider is designed for the utilities to recover the strategic investments. There's nothing that can change that. It's required. But if as a penalty they can't recover it for the first 4 months or whatever, as your example indicated, if that is somehow penalizing, because we were talking about that earlier, the utility for not having filed appropriately the first time on its initial filing, then that's what I would recommend.
Okay. There was, well, there was one other issue that you mentioned during your opening that you said you were willing to answer. It's probably more appropriate for attorneys rather than witnesses. It's staff's argument that Ironwood, I'll try not to call it Lake Catherine since the name has changed.
Yeah.
It's not recoverable because there was never a commission determination that it was a strategic investment.
Correct.
What, can you point me to where in statute it requires a commission determination that it's a strategic investment? Because I believe the statute reads that the utility gets to make that determination. Or at least that election.
In 23-4-1305C, it says an annual update required under subsection B of this section shall include the information stated in subsections A through B of this section for strategic investments following subsequent orders approving strategic investments.
And you read that as the approval has to include some acknowledgement that it's a strategic investment and not just that it was approved. They elect, the utility nominates, this is a strategic investment, and they can point to an order where that project has been approved. You're saying that approval also had to include some language that, and it's a strategic investment.
Correct. The commission is tasked with determining what strategic investments are. I think it was 1303. 1303.10 has two subsections, A and B. The definitions in subsection B, the facilities, can be easily determined. The commission still has to make the determinations in subsection A that it's the facilities in the public interest, that it's that it'll support growth and economic development in the state. It'll maintain and improve the provision of reliable electricity in the state. There's a list of findings that the commission has to make to determine that it's a strategic investment. Also, the commission has to find the strategic investment, not only that it's a strategic investment, but that 100% of the costs can be allocated to the retail class. So there's a lot of decisions that have to go, that the commission has to make to determine whether it's a strategic investment or not. And
So that statute allowed some, others may disagree with this characterization, some level of retroactivity, right? It covered some period of projects that had been previously approved prior to the enactment of the law, correct? And this facility would fall into that, right? So is it staff's position for this facility that they should have made a subsequent filing to get commission approval or acknowledgement or something that that facility previously approved was a strategic investment?
yes,
Okay.
13, this is long. I think it's 1304 W, I believe, is the section you're referring to. We addressed it in our briefs, and it says, the first thing it says, an expenditure associated with a strategic investment. And then it has to meet all the other qualifications, like it has to be the approval docket for the CECPN or whichever docket, whichever facility they're using has to be in effect pending during, before the act was enacted, and the act has, it has to enter, the order has to be entered after January 1st. All of that would apply, except that it has not been declared a strategic investment, which is the threshold question. When you're, as every attorney in the room knows, when you have a statute, you have to interpret it and you have to interpret with the intent to the intent of the legislature. When you are doing that, you'd have to take the language in the plain, ordinary meaning. Now, I think we also all agree that Act 373 is not a touchstone of clarity. So when you're interpreting this, you have to take the language just as it reads. And the threshold requirement is that it's determined as a strategic investment.
I don't have any additional questions, Chairman.
Ms. Anderson? No additional questions. Stand down, please.
Thank you.
I'm curious, Mr. Tate, you asked a question there about whether the commission had to act on Ironwood.
Yes, staff
we see-
staff during their opening mentioned that that they thought that was a more appropriate question directed at their counsel, and was willing to answer that question. So, if you would like the others to answer that, I will say we have one other party that filed a brief. If you want to give them an opportunity to address these issues, since
I
they
think if they
filed
would
a
like
legal
to
brief.
address that, I would like for them to address it. Ms. Laws, do you wish to address that issue?
So with respect to the issue that Commissioner Tate was just talking about with Ms. Kelleher, first of all, I don't think we necessarily agree, although I'm happy to address it from a legal standpoint. I think the law is clear and unambiguous and doesn't require any interpretation on what a strategic investment is. It lays out what that is, and staff proffered a witness to opine on what that was and had agreed that it met that definition, just that there hadn't been a finding. We put up Mr. Palmer, who can also address that from a factual standpoint. So I don't think it's a legal question, but I think Commissioner Tate, to your point, 1304W was, Ironwood specifically falls within that criteria to be included, and there is nothing in here that requires a specific order in a CECPN docket or another docket finding that it met any of that criteria. However, in the Ironwood order, even without using the magic word strategic investment, you can find that the commission did find all of those elements in the order. And you'll see that we had cited to those in our testimony so that you can see where those findings were made, even without that word, which we didn't know at the time. So there's not a specific requirement for that here. There's also not a specific requirement that it had to be in the underlying docket. So if the commission needed to make a determination as to whether or not it was a strategic investment, should it not have been clear, that could certainly also be done in this proceeding. It's not one that needed to have been done separately.
Thank you. Question?
None of the parties disagree, right, that this is a strategic investment. It's just whether we've made that determination.
That's correct.
Okay.
Yes. And Chairman Webb, there was a factual matter that Ms. Kelleher brought up in her response I'd like to address, but if you would prefer to have AAEA address your questions
I would
first, I can
prefer
do that.
you not address it, because if I do that, I'm going to open up the whole slate for everybody to come back and comment on each other's interpretations. Okay? So you may stand down.
Certainly.
Okay? Thank you. Mr. Coach, do you have some question about the strategic investment question? Ms. Lenz, we need to move this thing along, so I appreciate you.
Yes, sir. Thank you.
Yes.
The AG actually didn't file any testimony on this issue, so the AG is going to just not have a comment at this time.
Thank you.
Thank you, sir.
We love no comments. Who briefed it that you suggested?
AAEA also briefed the legal issues that we've been discussing. So if you want to give them an opportunity, I don't know if they intend to address it here today or not.
Do you want to address that, sir? That limited question?
With regard to the limited question on Ironwood, like the AG's office, we did not brief that, nor do we have any witnesses on that particular issue.
No, not on Ironwood. You did file a brief on the other legal issues, though, and you've not had an opportunity to speak to those. I don't know if you intend to or not.
You may proceed.
Thank you, Commissioner. Yes, briefly, in response to several of the legal issues that have been raised, the association does view the tariff deficiencies and statutory deficiencies as analogous for these purposes. It's a delegation of authority that has been made and is appropriately within the commission's control. That delegation also extends to the questions regarding that determination. Why is staff making this determination? Because the commission has made an appropriate delegation through that tariff in this instance and has provided with a specific set of responses and a specific procedure that for this particular tariff with Gaja is not including other entities filing deficiencies. Similar to staff's concerns with the ability for a gaming of the system by other parties, the association agrees what's good for the goose is good for the gander. In this situation, there should not be an opportunity or incentive for a party to game that system. And the commission's determination that staff was appropriate and made those determinations is something that we agree with. With regard to whether or not a filing that is deficient is actually a filing, the association specifically briefed that our opinion is it is not. The annual filing shall include is mandatory language. If it does not include those items, it has not become that annual filing. The 90 days should run from when it is cured. The 90 days is required based on the filing, which, in our opinion, does not exist until it has become sufficient. That is not changing a statutory deadline and is instead applying the plain and ordinary language of the statute itself. With regard to one question Commissioner Tate had that did address issues surrounding Ironwood, what hasn't been noted is that if there is a lag and it's approved, there are still costs that under Gaja, Entergy would be entitled to recover. There's another annual filing coming in about a year. Whether or not it could be included there is something that can be addressed within the tariff, can be addressed by the commission, because they are still entitled to that recovery under Gaja if it is a strategic investment. That is not foreclosed if you determine that it is not appropriate at this time, as staff has noted. A future notation that it is strategic by the commission would remove their objection. Overall, the legal questions are primarily procedural. And because this is the first annual filing under what are likely to be multiple ones, the commission should encourage restraint and should ensure that there is the chance for all parties to take a full participation. While the tariff is not a rule traditionally, the standard that the Arkansas Supreme Court looks at rules is something that should be considered. In a similar situation where the Health Services Commission had regulatory authority over regional facilities, the court said a rule is not invalid simply because it may work a hardship, create inconveniences, or because an evil intended to be regulated does not exist in a particular case. Yes, it may be slightly more challenging for some of the parties at the table involved with your decision. That doesn't make it wrong. And the association stands by the briefing that it has filed that the plain and ordinary language has been appropriately followed by staff in this case, identifying deficiencies, and that it is when they issue that cure notice that the statutory timeline begins to run. If the commissioners have any additional questions.
I just like you using language that I understand. What's good for the goose is good for the gander. I appreciate that.
Always
That's
glad
good
to be
old
of
Saline
service.
County talk. Any questions? We're going to take a 10-minute break, and then we're going to come back and start with Ms. Land with your first witness. Okay?
Thank you.
Yes. You may. Sorry.
A few
I'll make-
extra steps is good for me.
I'll make it brief. To be clear, you suggested that if expenses were to be recovered this year and were not because of a delay in filing, they would be recoverable in a future.
It's
Annual
possible they
update?
could be. Your specific hypothetical involving a lag
Okay.
in, let's say, certification. As you
Okay.
noted, there's a right to recovery, but there's also a necessity to follow certain rules. There may be a reduced overall return that they receive over the length of that project, but those costs would still be something that had not yet been included in rate base and under Gaja definitions would appear to be something that could be considered in an annual filing.
I think you heard my example earlier that Entergy made this filing on March 6th. under the language, I believe, in the statute and in the tariff, future annual filings are due on or before that date. You suggested a filing under the statute that doesn't meet all the requirements is not a filing. So, as an example, if they made a statutorily deficient filing on March 5th, and those weren't cured until after that date, what happens? Did they miss their filing for that year and get no recovery under the rider?
I believe that the prudent course for the commission would be to relate back their timely filing for the cure, but the statutory deadline runs from that cured filing for other parties. That deadline is as much for the commission, for the AG, for the other parties, as it is for ensuring those rates are met. A March 5th good faith attempt to meet that requirement that needs to be cured should not penalize the investor-owned utility once it is cured.
But you're suggesting for purposes of the statute, a filing is a filing for meeting that requirement that it be on or before that date, but it is not a filing for purposes of triggering the 90-day timeline.
That is correct.
Okay. That's all I have. Were you wanting to take a break, Chairman?
Yes, we're going to take a 10-minute break.
Okay.
Be back, and we may just be in till noon, but we're going to use the time as wisely as possible. We stand in recess. is here, and that means it is lunchtime.
Have everybody?
Okay.
There's, looking for you, Ms. McQueen. There you are.
Okay, I just want to make sure everybody's here before we go. The chairman had to step out. He's dealing with a health issue, so I'm your.
You're stuck with
unwilling-
us.
And I guess I'll be acting as your unwilling chair for the rest of the meeting. Do we have any other issues we need to take up before we move on to witnesses? Seeing none, I guess, Ms. Law, call your first witness.
So Entergy Arkansas.
One thing before we get started, I will say, although the chairman's not here, he will have access to the full transcript and a recording of this hearing, so he will be able to fully participate. So go ahead. Thank you.
So Entergy Arkansas is going to call Mr. Matt Morey and Commissioner Tate. While he's making his way up here, I did not hear the commission's usual instruction regarding the rule this morning, but I know from Judge Hickman's email you all will apply that. So we would issue our standard objection to
Okay.
the application of the rule.
All right. Thank you.
Okay. All right.
Ms. Law, you are very soft-spoken. If you'll just make sure you stay close to that mic, okay?
I wish other people would tell me I'm soft-spoken. I hadn't heard that one lately. Okay. All right. Mr. Morey, can you please state your name, title, and business address for the record?
Yes, my name is Matthew Morey. I'm the manager of regulatory filings at Energy Services LLC, and my business address is 639 Loyola Avenue, New Orleans, Louisiana 70113.
And Mr. Morey, are you the same Matt Morey that provided direct testimony and exhibits on March 6, 2026?
Yes, I am.
And rebuttal testimony on April 20th, 2026?
Yes.
And if I asked you those same questions today, would they be the same?
Yes.
So consistent with Judge Hickman's pre-hearing email, each of these testimonies, I believe, has already been admitted into the record, and so we will tender our witness.
Okay. For cross-examination, we're going to start with the AG first. So is that you, Mr. Lewis?
Yes, sir, it is.
All right, all yours.
Good afternoon, Mr. Morey.
Hi, good afternoon.
Two of these is a little different for me. Do you have your testimony handy?
I do.
Could you please turn to page 4 of your rebuttal testimony?
Rebuttal. Let's see.
And Mr. Morey, you're going to have to pull that mic closer
Oh,
to you.
I'm sorry.
Sorry.
Fair enough.
As the chairman says, eat it.
Got it. Got it.
And I can hand you this if that will help.
Okay. Let's see.
What is that document number, Mr. Lewis?
Document number 67.
Thank you.
Just one moment. Okay, I have it.
Okay,
What-
can you
What page? I'm sorry?
We are on page 4.
Page 4. Okay. Okay.
Would you read out loud the highlighted portion that I have on page 4, which is line 20 through 23?
20 through 23. So it says, conversely, short-term debt is typically used to finance short-term business activities, such as accounts payable, payroll, etc., and is often limited to certain constraints and borrowing limits.
Okay. And you don't list construction or CWIP in that, correct?
No.
As a utilization for short-term debt?
Correct.
Okay. And you're an accountant, correct?
Yes, sir.
How long have you been working in the public utility sector?
About 12 years now.
Are you familiar with James C. Bonbright?
I'm not.
Okay. Do you have any reason to doubt me when I say he is an author who regularly writes in this field?
I would take your word for it.
Okay. I'm handing you a book he authored, Principle of Public Utility Rates, second edition, authored by James Bonbright. On page 312, will you please read the highlighted portion?
So the highlighted portion says frequently short-term debt is used as bridge financing. Construction is financed with short-term debt until it accumulates in an amount sufficient to justify a bond issue, then is rolled over into permanent financing.
Okay, thank you.
Okay?
So Mr. Bonbright and you kind of somewhat disagree about the utilization of short-term debt for construction, it would seem.
Yes.
Okay. Yes or no, short-term debt is normally cheaper than long-term debt?
I would have to say it depends on the contract for the short-term debt. If that short-term debt is financed through a financing agency, it's dependent on market. So
But normally it's cheaper, is it not?
I'm not sure if it's normally cheaper.
Okay. Uh, can you please turn to page 5 of your rebuttal? And on page 5, you highlight a number of perceived risk with what Mr. Myers has proposed. And on line 12 through 13, you state, Mr. Myers does not address these increased risk to customers.
Yes.
Has EAL conducted any analysis regarding these perceived risk as it relates or compared to the cost of short-term debt and the benefit it could have on customers?
I'm not aware of any specific analysis that we've actually performed, but in general, the risks that I'm referring to here are more or less interest rate risks. So, dependent on market conditions, economic forces, the cost rate for short-term debt could fluctuate. The short-term debt rate that we use in the Gaja rider calculation is based on a daily rate.
Okay.
It's an average daily rate. So depending on a point in time, depending on market forces, that could be higher than long-term debt rate costs.
But there's been no analysis done by you, or none that you're aware of.
None that I'm aware of.
Okay. The rate base that supports the capital structure for this filing, did that rate base have any construction work in progress included in it?
You might have to show me exactly which rate base number you're talking about.
The one that was utilized for this filing.
For this filing, okay. And are you referring to the one that was in my testimony?
Yes.
Just double check. Okay. Sorry, it's a lot of pages.
It's okay. Take your time.
Okay, I'm sorry. Can you repeat your question, please?
The rate base that supports the capital structure for this filing that we're here for today, did that rate base have any construction work in progress included in it?
Well, when we calculate the revenue requirement for the Gaja rider, we do have components of a return on rate base and a return on CWIP. Each of those components has its own before tax rate of return applied to it. And you can see that on filing requirement 4, page 7.
But correct me, the capital structure that you're utilizing from this, it came from another filing, correct? It was already in place.
Yeah, so the cost of capital that we use both for the benchmark rate of return on rate base and the benchmark rate of return, well, really the benchmark rate of return on rate base is from the last approved rate filing.
And at
in
that
accordance
time,
with the
there was
statute.
no construction work in progress included in that, was there?
I couldn't tell you that. I wasn't familiar with that specific filing and didn't necessarily work on that. But what I can tell you is that we did use the benchmark rate of return on rate base from the last approved rate case based on the statutes.
Okay. All right. I'll pass the witness. Thank you, sir.
Sure. Thank you.
Give me just 1 second. All right, Ms. Kelleher for staff, do you have any cross?
No cross, thank you.
Okay. Any redirect, Ms. Paul?
Briefly.
Okay.
Mr. Lewis, may I borrow your book that you just passed us about? Thank you. Mr. Maury, can you read the publication date of that book to me, please?
Sure. Looks like, if I'm reading the right one, second edition, March 1988, I believe. Yep, March 1988.
And Mr. Maury, did Entergy Arkansas or any utility in Arkansas have access to a rider to recover a return on CWIP at the time that was published?
Not to my knowledge.
Is the debt rate that EAL utilized in this filing consistent with the law in the Gauger rider?
Yes.
No further questions.
Commissioner Anderson, do you have any questions?
I do, thank you. Mr. Maury, I want to ask you a few questions about your response to deficiencies. Ms. Law, that's document 48, which I believe is HSPI. I'll give you a chance to get to that. So we may need to. There is a particular number on the summaries for Ironwood that is redacted, I believe. Is that correct? It's a grand total number.
Commissioner Anderson, you're referring to responses to data requests that were filed as document 46?
I thought it was response to deficiencies, document 48. Unless I wrote that down wrong. Trying to find the original.
No, I see them here. Are these data requests or sufficient? Okay.
It is response to deficiencies. Did you find it?
So I've got I have some of the response deficiencies. It was a very large Excel spreadsheet.
Yes.
And you said there's a particular line?
So I believe it was broken down. I just have it. I have some copies that are blown up a little bit for my own eyes. But there were there were two summaries one for Ironwood and one for Jefferson Power Station. And I don't remember how much of the entire spreadsheet I have, but it is, I can tell you that the first two columns of that sheet, it says original approved funding, and then it says current approved funding. Does that give you a better idea? And at the very bottom, there's a grand total in both of those columns. And I believe that number is redacted. I think we're having some trouble with the Wi-Fi, which is probably prohibiting you from being able to pull the document up. I know the AG may be having the same issue. So we're going to take a break for just a minute and see if we can't get the Wi-Fi situation resolved. So let's recess for about 10 minutes and see if we can get that figured out. Okay. All right.
All right, we'll be in recess till 1:30. If folks are ready. Yep. Okay. The document Commissioner Anderson was referring to is an HSPI document, so not all the parties in the room have access to that document. Those that have signed affidavits or have permission to view that document, I believe, are the AG staff and obviously the, obviously EAL. You guys have a copy or know what Commissioner Anderson is referencing, correct, Entergy? Thank you. The AG has also accessed that document, is that correct? Yes, sir. Staff, do you have a copy or can you access that yet? You do? Okay. Okay, well then I think we can move forward.
And
Commissioner Anderson?
APC was also provided access, so.
You were provided access to
Yeah,
that?
I mean, we were been provided HSPI in this case, so.
I've also been signed the HSPI records. That's it with the
Okay.
Oh, the affidavit.
Yeah,
Yeah.
Just one point of clarification, though, that while Ms. McQueen is correct that they have been granted HSPI access in other proceedings, they have not signed affidavits in this proceeding.
But
Okay.
Entergy has provided me HSPI in this case, so I would say they've waived any argument, but she is correct. I haven't signed an affidavit, so I can.
Okay.
If you want, I mean, if we need to kind
I
of.
don't,
push
okay.
back, you know, look
I appreciate that. I don't know that
Okay.
this is ultimately going to make a difference because I think Commissioner Anderson is just going to reference a number in that document. We just wanted Entergy to be able to identify what number she was referencing. So
Yes.
without any other objections, I think we'll try to move this along. Is that good with everybody? All right, let's do it. Commissioner Anderson?
Okay. Somebody, did I say something? Oh, sorry. Okay. Okay, Ms. Law, let's return back to what I'm looking at is the summary of Ironwood, the Ironwood CT at this point, which is, you've got that one in particular pulled up, correct?
Yes, ma'am.
Okay. I'm looking at the grand total at the bottom of the very top square, which I just have the one square, but you've got the whole document. Do you see which? I'm looking at the top
Yes, ma'am.
left, that particular
Following you,
box.
yes.
Okay. Okay. That particular number is the only one I need to ask a question about, but that number is redacted. So that's correct, right?
Yes, that's correct. It is redacted.
Okay. I would like for the parties to weigh in on unredacting that particular number. If you would like to start with you, we can go ahead with you, and then the other parties can weigh in. But I would like to unredact that number, and I would like you to weigh in on that, please.
Sure. And I think we can hopefully dispose of this one really quickly. There's not an issue with unredacting the total figure.
Okay.
However, this file was uploaded as an Excel. So it's a linked file. So all of the numbers go through formulas within it. So there isn't a way to upload it with a single number unredacted that doesn't compromise the file. If the commission, however, would like us to file something that states that number publicly as a grand total, that's not an issue. But the file itself, there's not a mechanism to upload one number unredacted in this form. So I'm not sure how
Okay.
we would practically
if-
accomplish it, but it's not a
Right.
concern to talk about the grand total number, if that helps.
If you're okay
Okay.
making that number public for purposes of the hearing, we can talk about that number. And if there's something you can file after the fact with that number in it, so it is public for everybody to see, I think that's how we can resolve this.
Yes,
Okay.
that should not be a problem.
Okay. Thank you. Does anybody else need to weigh in on that, or are we good to move forward?
Nobody objects to Entergy making that number public, do they?
I wouldn't think so.
All right, no objection.
Okay. Mr. Maury, here we go.
Sure.
It has been an interesting day. So let's get back to it. As we've discussed, I'm referencing the response to deficiencies in document 48. Do you have that document pulled up as well?
Yes, ma'am.
All right. That particular document reflects the dollar amounts that EAL is seeking to run through the rider for the 3 currently eligible projects. Is that right?
So I just see it for. Am I looking at the wrong? I just
Well,
see it
that's
for
the-
Ironwood.
It is, but yes, but there are 3 other, I think they're separate spreadsheets, right? Are they separate spreadsheets or are they all in one? I don't remember. It's been a minute since
Oh.
I looked at the whole thing.
Cost models for the.
I have a question about two of them, 2 out of 3 of them.
Right.
When
Yes, so they are separate cost models, and I think the
Okay.
one that we were looking at was just for Ironwood in that grand total column.
Right. But would you agree? I guess, let me ask you, there are 2 other cost models for 2 other projects. One is JPS and one is Cypress Solar, correct?
That's right.
That's right.
Okay. Let's look at Ironwood for just a minute. Or actually, no, let me ask you one question before we move to Ironwood. Would you agree that those documents each reflect the dollar amount for each project that EAL is seeking to run through the rider in the grand total column or line item at the bottom?
Let me just pull up a copy of the revenue requirement real quick. So I believe, just at looking at this spreadsheet, I believe that number is for the entirety of the project. So what we're seeking to recover in this rider is just the CWIP associated with the 2026 test year.
So the grand total at the bottom of, so let's look at Ironwood. Let's just break it down. I think that's going to be easier.
Sure.
Under the second column, which says current approved funding, actually the number's the same for the original approved funding as well. That is the number that we are going to discuss here today, correct? So approximately 782. Do you see that number on the line, the grand total?
Yes, ma'am.
Okay. So 782 million, correct?
That's correct. That's what I'm seeing on this.
Okay. Is that the number that EAL is seeking to run through the rider for Ironwood?
Are you referring for this particular year, or are you referring just to the entirety of the project? Because I think what we're proposing to run through this year is just the forecasted cost for 2026 that would end up in CWIP. So I think what you're looking at here, and again, this is a project management tool, so I'm just kind of interpreting it, but I believe that's total cost.
That is total
But
cost.
but not necessarily what we're going to run through CWIP in this year's Gaja Rider.
Okay. Let me regroup for just a minute. If you want to ask some questions, let me figure out because I've got some more.
I think I understand what Commissioner Anderson was asking. There may just be a disconnect. That total number, and since we've made it public, we'll go ahead and state it. That 781,972,174. Over the course of the project, that is the number that you will seek to recover through the rider. Not this year, but that is what you have identified as the cost of that project that will be recovered through the rider.
So that is total cost.
Okay.
So as of right now, based on this estimate, that is the total cost that I'm seeing on this file.
Okay.
That would be recovered over the entirety
Right.
of the build, not just this year.
Did you have follow-up questions?
I do, yes.
Okay.
Thank you for
go ahead.
clarifying. But
Sure.
that is the total project cost the total that you plan to run through the rider.
As of now, based on this file, that's what I'm seeing.
Okay. Can you help me understand why? First of all, let me ask you this. Under the column that says current approved funding, or the heading of that column, what does that mean when it says current approved funding?
So my understanding of this is a project management tool. That's probably refers to internal approvals, not necessarily like a commission approval.
Okay.
This is just internal project management cost tracking
Okay.
for this particular project.
Okay. So can you help me understand why the current approved funding amount for Ironwood reflects a dollar amount that is significantly higher than what the commission approved and where the commission instituted a cap on that project. The commission cap was approximately $542 million. But the number you have in the grand total is approximately $230 million over that.
I do not have I'm assuming that Mr. Palmer might be able to talk a little bit to that. I don't necessarily know. I wasn't too involved in that particular CECPN filing. So I couldn't really state why there's a difference in those numbers.
Okay, so you're going to punt that one to Mr. Palmer. Okay. Well, I had the same question for another document, so I will wait and ask Mr. Palmer about those. Commissioner Tate, I give it back to you.
Thank you. I'm going to go back to your direct testimony, Mr. Maury.
Sure.
I'm looking at Exhibit 1, page 2 of that exhibit. As part of that, you have rate class allocations. I'm looking at line 1 of page 2 of Exhibit 1.
Okay, I see you.
Where did those rate class allocators come from?
Let me just refamiliarize myself with this document real quick. So I believe that those are calculated numbers. So if you were to take the, say for example, residential, the $43 million or 43.4 million divided by the total, that would get you the allocation.
Do you have work papers on how you got those numbers?
I think
I don't recall those being filed. Would you have an issue filing those in the docket if you have work papers on how you derive those cost allocators?
sure, I'd have to probably consult with counsel to see if that's okay, but I don't know if there's a reason why we wouldn't want to have that.
Yeah, Commissioner.
But-
Matt,
I don't know that we can hear you on that.
can
You have
hear me?
another witness? Mr.
Yes, we have
Clutcher is going to
Mr.
address that?
Clutcher developed those allocators. You can ask him any question
Okay.
you want about the allocators.
You may also punt this one to Mr. Clutcher, but let's look, same page. I'm looking at billing determinants for the LGS class. Are those, is that amount that's listed there, that, what is it, 31 million KW? Is that based on firm load or does that include non-firm load?
Yes, Mr. That would also be a Mr. Clutcher
Okay.
question.
So, unfortunately, I think you were stuck in the room for that discussion this morning. So you heard some of the concerns about the abbreviated nature of this proceeding and the timelines everybody is under.
Yes.
As part of the filings, there may be updates or amended tariff sheets that need to be filed. Do you have any objection or any concern about in annual updates if Entergy agreed to adjustments raised by another party for Entergy to file those in rebuttal testimony?
I'd probably have to consult with counsel to see if that's something we can agree to.
Yeah, I don't think we have any concerns, Commissioner
Okay.
Tate, with filing those with rebuttal if necessary.
Okay. I don't think I have any additional questions. Do you have anything else you want to touch on, Commissioner Anderson?
No, nothing else. We'll get Mr. Palmer up here in a
Okay.
little bit.
Okay.
Thank you.
Commissioner Tate, before Mr. Maury sits down, did you all have questions from order number 5 that you wanted him to address? He is our witness for one of those questions. Or would you prefer to bring him back up for that?
I think if we decide to ask questions on that, we'll bring him back up.
Fine.
Ms. Law, call your next witness.
Well, then we'll bring up Mr. Clutcher now. So we'll call Matthew Clutcher.
I could be wrong, but you may have identified Mr. Palmer as next to the ALJ prior. Are you intending to take him out of order?
Well, I thought so that is correct. But Mr. Clutcher was identified in response to order number 5, and given your question just now, I wasn't
Okay.
sure if you'd want him, but we're happy to bring Mr. Palmer instead if you'd prefer.
I'm fine if you don't. Okay. This is fine.
All right. So, Mr. Clutcher, please state your name, title, and business address for the record.
Matthew Clutcher, Director of Utilities, Rates and Pricing for Energy Service LLC. Work address is 639 Loyola Avenue, New Orleans, Louisiana.
And can you please describe your current role at Entergy and your general background?
Yes, as the Director of Utilities, Rates and Pricing, I lead the teams that service all the energy operating companies for any rate design, cost allocation type of needs, including Entergy Arkansas.
And we had
Yes.
identified Mr. Clutcher in response to order number 5, but of course, if the commission has other questions for him, he's available.
So you identified him in response to our order. Is there any cross for this witness since he did not file direct testimony? Staff? Nothing from the AG? Okay. Commissioner Anderson, do you have any questions for Mr. Clutcher?
Not with regarding to order number 5. If you want to go ahead with that, that's fine.
Well, since he's up here, I think we're just going to take any questions we have for him. So
Okay.
I'm happy to start.
Go ahead. Yeah.
Okay. Why don't we go ahead and address that first question I asked Mr. Maury, which is looking at his exhibit 1, page 2, those rate class allocators. Can you tell me how those were determined?
I do not have a copy of that in front of me, but I think I
Okay.
know what we're talking about.
Let's see if
Okay,
your
let's-
counsel can help you out.
Okay. Okay, yes. So the allocators, which is there on line 1, that's the allocation that we use to allocate the revenue requirement on line 2. Those allocators were the allocators that we presented in the docket last year, 25, maybe 047, I believe. I might have that wrong, TF, in which we were talking about the different types of allocations we could use for this particular rider.
Mhm.
And as part of that outcome, the commission order stated that we would use the allocators that I presented in my testimony for an adjustment to take what was in the PDAF for the last rate case and adjusting it for some customer adjustments that we needed to address. But going forward, we would have to use updated allocation factors every year. But for the purpose of the first one, we were using what was done in the 25 docket.
So I understand this is not your exhibit. You didn't file this, but are there work papers associated with how those numbers were calculated using?
For line 1,
Yes.
they would have been in the 25 docket. There were work papers.
Those are pulled directly from that
Yeah,
document?
yes, from
Okay.
that docket there. That's correct.
The second question I asked had to do with let's see here.
The billing determinants.
Yes, for the LGS class.
Yeah, so that 31,000 would be firm load.
It's firm load. Okay.
That's correct. Or, sorry, total load.
Total load.
Uh,
It
yeah.
includes non-firm.
Non-firm and firm both included. So the Gauge rider does not have a distinction between interruptible versus non-interruptible loads.
Okay. In docket 25049 TF, you filed testimony and exhibits that showed a projected impact through the rider this year of $7.09. Do you recall that?
I recall filing impacts, but I don't recall the numbers necessarily.
Would you agree that the number that is that is filed here is lower than that projected amount previously?
Yes, if it was $7, it's lower today.
What does that reflect? Is that reflecting total project costs have changed, or just that your pace for construction and spending associated with that has changed?
I can't speak to what changed the number. All I can say is it's lower because for the purpose of the rate design, I had a lower revenue requirement to use.
So who would be appropriate to answer that question? Because it doesn't appear that the amounts of projected spend have changed, just the number you're seeking to recover this year through the rider has changed.
I'd probably need to defer to my counsel for who would address that question.
I think Mr. Palmer can probably address that at a high level.
Okay. Can you tell me whether special rate contract customers are paying into this rider or are responsible for paying this rider?
Any special rate contract customer who exists today would be subject to this rider when it goes into effect this year.
Okay. And is that reflected in the respective classes' billing determinants?
Yes, it is.
Which rate class is Entergy projecting to realize most of its projected load growth?
I guess it would depend on how that ultimate customer is contracted through the company. If it's contracted through a rate class, a normal rate schedule, it would more likely go through the LGS rate class. That's where our largest customers take service from, or it would be a special rate contract. And for the purposes of the Gaja rider, those customers, if they're subject to the Gaja rider, would be included in that particular rate class.
Okay. Looking at that same exhibit again, under projected billing units for residential, do you see that number there?
Yes.
What is that number?
That would be, I believe, 7,543,369,088 kilowatt hours.
And are you familiar with the Entergy's FRP docket?
Yes.
That number filed there for projected billing units is similar to what was filed in its FRP docket. Is that correct?
It would probably be similar, although they're different test years.
Okay. Entergy recently filed its rate case, right?
That is correct.
Are you familiar with the projected billing units for residential filed in that docket?
Yes, I am.
So the number included in its rate case filing is noticeably larger for projected billing units for the residential class. Can you explain why?
So the numbers that we're using here in the Gaja rider would be forecasted KWH. And for the most part in the rate case, that's going to be normalized actual sales with a 6 and 6, where I guess 6 months would actually be projected. But one is, they're kind of developed in different ways. Someone's using some actual, some projected, whereas the Gaja rider is using fully projected data.
So that 6 and 6 number is noticeably larger than what you're projecting through the Gaja rider?
I haven't compared the two, but if you looked at it that way, then that may be the case, that they're different.
So help me understand why you would project a significantly lower number of billing units for residential.
So I don't work on the forecast, so I can't necessarily address what would go into the forecast in KWH. Again, that's done within another group in the company, and I just use those in development of our rates when it comes to rate design.
Well, I'm just trying to understand. You've had 3 successive filings, and that number seems to be going back and forth. You had the FRP filing, which included a number close to that 7.5 number we're seeing here. Then you had, I believe, the rate case filing, where you saw a significantly larger number, that 7.8 number. and then this filing, and you went back to the 7.5 number. So I'm trying to understand why that number for billing units for residential is moving what seems to be a fairly significant amount.
I don't know if I can answer that question here today. I have to go back and try to take a look as to what the differences are that's driving it. But anytime in the forecast, you can see that, the actuals in the forecast usually do never turn out the same. It's fairly common, which is one reason why, a lot of our riders, we have true ups that take care of that difference as you project kilowatt hours into the future, that when you look back and you do a true up, you average to true back up to the actual kilowatt hours. And a lot of times weather has a big impact, particularly on the residential class.
Give me just a second. I've got to flip to a separate exhibit. Do you have any questions you want to ask in the interim, Commissioner Anderson?
Not right this minute. Thank you, though.
All right. Do you have Mr. Maury's direct exhibit 2 in front of you?
Okay. Yes.
So what's included in that filing is the EIA all sector data reflecting the national average, correct?
That's correct.
And what is that national average?
The national average as of this was 12.94 cents per kWh.
Now that report covers what period?
That would be for calendar year 2024.
Okay. So there's a bit of a lag between that and what we're talking about today is what the actual rates will be.
That is correct. The EIA data is on a lag, so you don't get the actual calendar year data until October of the preceding year. So, for example,
but it's that report that acts as the cap, right?
It is one that provides the constraint information for this particular filing, yes.
Can you provide an estimate for the rates for each individual sector for 2026?
For each individual sector?
Yeah.
You can get that from the data. That is correct.
For 2026?
Well, not for 2026, sorry, but for the data is done by sector. But, for the purposes of the Gaja rider, it's at the all sector level, so it's the total company.
Do you have a projection what that rate will be for all sector or individual sectors?
I don't have a projection today for 2026. I do have a projection for all sectors together, which is total company essentially.
So if you can provide a projection for all sectors, is it possible to provide a projection for the individual sectors?
I would think you could probably make a projection the same. You could take the same projection we included in the all sectors and try to, deliver it between the different rate classes that you would have.
Is that something you can provide to the commission?
Yes, we could provide that to the commission.
So looking at that 2024, if you're looking at just the residential sector, how does it compare to residential sectors nationally?
I don't know if I know that sitting here today. I don't have that information in front of me.
I think that's all I have at the moment.
I don't have any questions right now. Thank you.
I think that's all we have for Mr. Clutcher at the moment. If you want to call your next witness, Ms. Law.
So EAL calls David Palmer. Mr. Palmer, please state your name, title, and business address for the record.
David Palmer, Vice President, Regulatory Affairs, 425 West Capitol Avenue, Little Rock, 72001.
Are you the same David Palmer that provided rebuttal testimony on April 20th, 2026?
Yes.
And if I asked you those questions today, would your answers be the same?
Yes, they would.
So consistent with Judge Hickman's pre-hearing email, I think his testimony has already been admitted into the record, and we would tender the witness.
All right, Mr. Lewis for the AG, do you have any cross?
No cross.
All right. Ms. Kelleher for staff? No cross? Commissioner Anderson?
Yes, thank you. All right, Mr. Palmer, let's circle back to the questions I had for Mr. Morey. Do you have the document in front of you that we were referring to, the response to deficiencies, document 48?
I'm about to.
Okay.
Okay.
Let's look at Ironwood first. Let me know when you have that up.
Reading their password right now.
Change it right after this.
Now I have one.
Okay, and I'm sure no one has ever told you this before, but you've got to speak loudly into that microphone. Okay. Can you help me understand why the board approved and current approved amounts for Ironwood, which we have now unredacted those numbers, this table reflects 782 million.
Correct.
Why that is approximately 230 million above the cap that was instituted by the commission. Cap was approximately 542 million.
Well, just a point of clarification. I didn't appreciate that the commission, and I thought there was clarification here in the docket that was an actual cap. The commission established a benchmark cost estimate for purposes of approving the project to proceed.
Okay, well,
But-
whatever it was called in the docket
Right.
or
Why
in
this
the,
number is different than the
in the
benchmark.
opinion, why is the number 230 million more
Than the benchmark.
than the benchmark?
Okay. Well,
If we want to call it whatever it is,
right. Whatever it is.
whatever
And
it is,
so
why is it more?
you can actually just set that issue aside. So even if we didn't have this rider and we were making an investment in an asset, we're going to take our estimate for that asset and we're going to accrue AFUDC in a normal circumstance or a historical normal circumstance. And that would be how we accumulate our financing costs over time that ultimately roll into rate base as plant and service. Here, the only distinction is we're not accruing AFUDC, we're using return on CWIP through the rider, but you're still using the cost estimate for the resource regardless of where you provided as your cost estimate, because we always know that number is going to move anyway. So if our estimate goes up or down, historically AFUDC would change, here CWIP would change. It's the same mechanics.
But the number you're planning to run through the rider is 782, according to this document. 782 million, correct?
I would say the number, the 782 in our current capital outlay associated with that expected cost estimate is driving the amount of CWIP we have in the rider for this period. We don't yet know if that final revenue requirement will be tied to 782, 500, or something larger. So I don't think I could say today what the revenue requirement is going to be in 5 years. I just know today our current estimate is somewhere around 780 million.
Okay. But you're not suggesting that you can recover from ratepayers an amount higher than that's approved by the commission.
I think we present what we are seeking recovery of, and the commission has a discretion to decide if that's reasonable.
Okay.
We're not presupposing or predetermining that you've found it prudent for that investment cost to be $800 million. We're
And
working off of our current cost estimate.
I presume your answers would be the same for the Jefferson Power Station
Correct.
spreadsheet,
Correct.
because that too is also listed at 1.6 billion, which is over and above the 1.5 that was approved.
Correct. I would say
Okay.
my answer would be the same regardless of the asset, regardless of the
Okay.
recovery mechanism.
All right. Shifting gears just a little bit, since this is our first year working through this tariff, do you have any recommendations or suggestions for future years that might help this process move along in a more efficient manner? I would like to hear your thoughts on, because this is a learning exercise for all of us, right?
Yeah.
This is the first time we've addressed these issues. So I would like to hear your thoughts on that, please.
Well, if I could offer one thought, there's been a lot of discussion leading up to the witnesses being able to discuss their testimony. I think there's been a great deal of time spent on solving issues that aren't currently present. So we're thinking about, there's a lot of discussion around, well, what if the utility doesn't do this? What if the utility decides to just completely abandon all of the filing requirements? We went through a fairly extensive proceeding last year to establish 18 filing requirements in collaboration, but also in response to the commission. And we proceeded with that filing. We have had discussions with staff. I believe we may have had a couple brief discussions with CURAD following that process. We ultimately maybe had a disagreement relative to what is a deficiency or not, but we filed the work papers that we possessed to be attached to the filing requirement. The discussion with staff generated the need for those work papers to be constructed a different way, and we provided those immediately. And as we sit here today, regardless of all of the discussion around, well, what if this and what if that, staff was able to conduct their review under the timeframes and the statute and has a recommendation today. So I think it's been a learning process, and there's a lot of things that may play out in the future. To the extent some of those things materialize, require some collaboration, which we're more than happy to do. We're, to Ms. Law's point, to the extent there are edits to the tariff to be made prospectively to make it more efficient. If, as an example, if the structure of that work paper that we provided staff needs to now be the way it's provided in the future, which I assume that's how we're going to do it, if that needs to be made a filing requirement, we're happy to have that discussion with staff. We would always welcome that. But I think that's ultimately how we move it forward. We worked through a pretty extensive proceeding to land on what's required. There's always going to be some tweaks to how that information gets presented, and it's just a collaboration. But we're happy to have that. But I think this is how the process is working out, and we're obviously learning through it. I just don't want to dismiss the fact that we're talking about, in my opinion, some hypotheticals around the utility not taking certain actions and, not following a filed rate. That would never be our intent. But certainly, I don't believe any of that really comes into play for this rate. We've clearly satisfied what was needed, and the reviews have been completed, recommendations made.
Well, I think you would at least agree with me that this first docket has brought up some interesting issues. Would you agree with that?
This current proceeding,
Mm-hmm.
I would ask you just for your opinion, what interesting issues in your mind, because I'm happy to take
Well,
that back.
it's your question, Mr. Palmer,
Yeah.
not mine.
I
Thank
don't know
you, but
what-
no.
yeah. But if there's feedback, in all seriousness, if there's feedback on what has been challenging to work through from the commission's perspective, we certainly want to hear it.
Well, we'll have time to discuss that later on, probably as we work through things. But shifting just a little bit, this is also an opinion that I would like to seek from you. Should all parties be permitted to file deficiencies within the prescribed time frame? To file the prescribed time frame to file deficiencies within the tariff?
I could argue this one both ways. And I will say I probably agree with Mr. DePippa. I think the company needs some assurance that just like going into this filing, we knew staff was going to review for deficiencies because they're tasked with doing that. At the conclusion of a very extensive docket where we established all of those requirements, and if we open up to multiple interveners having their opinion, I think if anything that's been demonstrated today, there may very well be a reason for other parties to use that as a platform to argue that there should be a delay. So I think I would disagree that every party should have the right to decide what a deficiency is. That's my opinion for now.
Okay. I may have another one in just a minute, Commissioner Tate, but I will let you move forward with your questions or pass it back to you.
Thank you, Commissioner Anderson. I want to follow up on her questions about what is listed here going forward for those resources. That 781 million number that is listed. You're calling it a benchmark, and that may have been what the ALJ called it in her opinion. What is Entergy's intent when it gets to that number? Will it continue to run costs through the rider associated with that resource, subject to refund? Or will it notify the commission? Will it seek commission approval to continue running costs associated with that facility through the rider?
As I recall, the mechanics of the rider would be whenever we have the final cost, we would include them in the rider, subject to review and subject to any additional support we would have to provide to substantiate any differences. And other parties would have the opportunity to, weigh in on that. But I believe that's how the rider is intended to work until the assets roll into base rates.
So despite that lower number, both with Ironwood and with Jefferson Power Station, Entergy will run through the rider, potentially more. The number it's identified, not what the commission identified, again, subject to refund and that prudence decision at the end.
Don't have the tariff open. I don't know if the subject to refund language is in the tariff, but
You don't think an amount recovered or collected by Entergy not approved by the commission is subject to refund?
I don't recall whether there's a true up provision in the approved tariff is where I'm going. So we would provide our final cost and we would provide support for our final cost. I don't recall whether we're going back and truing up to a cost estimate. We made some proposals around that in the docket last year. I just don't remember how that's worded in the tariff.
So for Ironwood specifically, that benchmark number was 542. You guys have identified 781 as the approved funding number. I assume that is approved by the board, not the commission.
Correct.
So if that is what you ultimately collect through the rider, and at the end the commission determines the amount over 542 is not prudent, what happens? You seem to be suggesting that the amount you've collected over that 542 is not subject to refund.
Well, I'm not suggesting it wouldn't be. I'm suggesting that I don't recall whether that language is in the tariff. Whether there was language removed around whether there is or is not a true up to cost and how that functions. What I'm not recalling is exactly how that works. So I don't believe I would sit here and say that, and I'm not, that if the commission determines a cost was not prudent, that we would still have a right to recover that cost. I just don't know how mechanically that plays out when we get to that final cost estimate.
But with this rider, it's not whether you have a right to recover it. You've already recovered it. So what happens with that amount that is deemed imprudent?
And when you're describing we've already recovered it, we have gotten to the point to where we have closed it to plant and service, and we have the final, I'll call it per book, net of depreciation rate base amount. And that would go into a rate before it's been reviewed for prudence.
Yeah, it's the amount that you've already run through the rider based on the numbers that you've identified, not what the commission's identified.
Well, in the last period of construction, we would still be working off of the CWIP associated with the cost estimate. This would be in a world where we are post-close on the resource and we have final cost. And we'd be proposing to put that rate base amount in as opposed to the CWIP or return on CWIP.
All right, I'm going to ask a broader question, and hopefully you will take this opportunity to explain more generally to the public how this works through the rider. You testified in 25055P, right?
I did.
And Entergy has continued to make public statements that the full costs associated with Cypress Solar will be paid for by Google. Is that correct?
We've said their contract is structured so that they financially support the full cost of Arkansas Cypress.
I think you have said that. Others on behalf of the utility have said Google is paying for Cypress, all of Cypress.
Okay, I'll take your word for it.
So explain for those that are in attendance, for the public generally, how both can be true, that Google is paying for all of Cypress, but we see as part of this filing, part of what is being recovered here is costs, CWIP costs associated with Cypress.
Right. And what's not easy to explain to, I'll say, a typical customer is you're looking at one side of the equation. The cost for a resource go in mechanism A. The revenues from a customer may go into mechanism B. From a total bill standpoint, the customer gets to the same place, but you see a rate because mechanism A has a rate in it, but you see something different in B than you otherwise would have. So when we constructed, that contract, and as others, we necessarily have to address that issue. Especially for a customer, of significant size, we're making investments, and those costs don't necessarily show up all in one place. Certainly not when we have, two mechanisms. So the contract was structured so the customer financially supports the full cost of that asset. From a rate implementation standpoint, the cost is not showing up in the same place that the revenues would show up.
And you wouldn't dispute, though, that costs associated with Cypress are going through this rider that all customers will pay for.
Correct.
But when you make the comment, or that Entergy makes the comment that Google is paying for all of it, you're suggesting that the rates they will pay over the life of that contract and potentially longer will more than cover the costs associated with that facility.
That is accurate.
But in the short term, customers are fronting the cost associated with Cypress.
Customers are seeing a rate for our initial construction activity. That's true.
This commission has been particularly sensitive about the amount of HSPI, not just in the special rate contract dockets, but in resource dockets as well, all of which I think you're familiar with.
Yes.
And I think this commission has urged, as that information becomes public, it should be unredacted in the underlying dockets where it was held out as HSPI. Would you agree?
I wouldn't dispute that, no.
EAL makes FERC filings, do they not? They're required to?
Like our FERC Form 1 annual report, that stuff, or other specific FERC filings?
Well, let me see if I've got the specific FERC form, so I can give you a FERC form number to look at. I believe it's FERC Form 1, so I believe this was filed on April 3rd. Are you familiar with the filings Entergy makes to FERC?
Yes, somewhat.
Let me first ask, as part of that special rate contract, there were amounts that were paid by the customer to Entergy that were considered not kayak, correct? I think they were labeled as other contributions.
I'm only hesitating as I try to recall what was and was not redacted, but subject.
I don't believe the fact that there were contributions that were not considered kayak was HSPI, but
okay. Then yeah, I agree.
For the reporting period, so Q4 of 2025, were there any customer advances paid by any other customer?
For Q4 of so the end of last year, Were there advances paid by other customers for other projects?
Right. That would have been included in this report.
Well, I'm not familiar with exactly what is reported and what you're looking at, but there's no special rate contracts otherwise taking effect in 25, if that's the question.
So what I'm looking at is FERC Form number 1, specifically what is listed under other regulatory liabilities. There is a line item for customer advances minimum billing that you guys have filed with FERC. And to
Okay,
be clear, those filings are public, right?
correct.
So there were some minimum bills, customer advances provided by the customer that were held as HSPI as part of that special rate contract docket, correct?
Correct.
But it appears that amount for at least that quarter has now been made public in a filing to FERC. Would you disagree?
I would disagree that any amounts, I don't want to get too far into the customer contract.
I
Let me
understand, but
say,
what
I'm not aware.
what this commission has said is that when those amounts are made public otherwise, they need to be unredacted and made public to its customers here.
And I appreciate that. You're asking me about revenues from 25, and I'm trying to not disclose whether and to the extent any of those revenues came from a specific customer.
And I asked previously whether you guys received any customer advances specifically marked as minimum bills from any other customer.
Well, we clearly did because that's on the FERC Form 1. I don't know what is defined as a minimum bill or customer advancement for purposes of FERC. What I'm
Well, this is how
leery of,
this is how you guys have classified it.
but what I'm leery of is associating that number to that special rate contract because there are timing considerations. And I don't want to disclose timing inadvertently if that's sensitive.
Right. As part of that contract, there's a schedule for those payments.
Correct. I don't know if the schedule is public.
Okay. So what wouldn't be public, it appears, at least based on your filing here, is future payments. But it appears if a payment was made and reported here, that payment is public. So my question is, why should that number and that payment not be made public? It's been made public in a FERC filing. Unless you're suggesting that number, as it's listed here, contains more than one customer advance from multiple customers.
What I'm trying to draw out is I don't know that that number contains anything from the customer in question.
And you feel confident about that based on the schedule that was provided in that previous docket?
If you're reporting a Q4 25, I'm very confident.
Okay. How familiar are you with Exhibit A that was in your application in 25055P?
Off of memory, probably not very familiar. And there's a distinction in my answer because you're specifically asking about non-kayak payments.
Mm-hmm.
So again, I feel like I could fully address this. I'm just very leery of going into that contract without a full version of it to know what's confidential and what's not.
Ms. Law?
Commissioner, I was just going to offer too that, and I'm not looking at the FERC Form 1 that you're looking at, but I don't think it would disclose a particular customer, so it would be assumed it's an aggregate for anything. I think what Mr. Palmer is struggling with here is then we would be identifying specifically that customer in that contract that we're bound to keep confidential.
And I asked the question, and maybe you can answer it, whether you have received customer advances from more than one customer.
I do not have the answer to that question.
Is that an answer you can get the commission?
Certainly.
Can I ask a clarifying question?
Sure.
When you're referring to advances from a customer, are you focused solely on those that we would characterize in the same manner as were the contributions from that special rate contract, or any?
This is how Entergy has identified it in its FERC filing. Customer advances minimum billing that they've listed under other regulatory liabilities, account 254, on its FERC Form 1, specifically for the period of Q4 2025.
Okay. So a breakdown of what is in that FERC account for that period is what the commission would like.
What does that include?
I'm sure we can get that breakdown. I'm only struggling with what is an advancement and what is, that's all.
I think I just have one last question. Commissioner Anderson, do you have anything before I hit this last question? Well, I take it back. There may be one additional question beyond that.
You can continue, and then if you ask the question I'm thinking of, then we can let it stop it there. But if not, I'll ask one final question when you're done.
Looking at the tariff, sheet 4 of 20, do you have that available to you?
I believe so. Give me 1 minute. Which sheet? 4?
Yeah, now I think I've split up that tariff because I didn't have it stapled, so give me a second. I may have to track down sheet 4 as well. What we're looking at here is section C. It discusses if Entergy experiences a material change in estimated construction costs, which for purposes of the rider is the lesser of the contingency approved in the underlying docket or 10% of the total project cost. EAL shall immediately file testimony with the commission. Do you see that language?
I'm reading it now.
My recollection, this was of specific importance to the chairman who is not with us this afternoon. What is your understanding of the word immediately for purposes of this provision?
Let me just read it real quick. The question is what I would say is immediately.
Yes.
Yeah. Sorry. Yes, sir. I think it's probably a bit circumstantial based on what the cost is. So just as a hypothetical, sitting here today, we may see a material change, that, if you recall our contracting structure through our, fixed price EPC or otherwise, there could be the case that we see a cost change, but as we sit here today, it may not necessarily make our overall estimate change because there are other components in that contract that we don't see risk on, or maybe we have worked risk out of. And so there's necessarily a period of time where someone could argue that, well, you had that change, but you didn't immediately file it, but I didn't immediately believe it was actually going to influence a material change. So it's probably a little bit of discretion that I would say is needed in determining what immediate means. And I believe we're talking in terms of during the construction period. So there's several variables that would come into play there.
Right. It's a material change in estimated construction costs, right?
Right.
So do you have any current projects that you believe the estimated project costs exceed due to the contingency approved or 10% of the total project cost?
Of our cost estimate, I think we're still on track with our estimates.
And you're basing it off your estimate, not the commission benchmark numbers.
Correct.
So for Ironwood, as an example,
Our
you're
est-
basing it off the $750 million number. 700 and, well, I've lost the 700.
780
Yeah, that number, rather than the benchmark
than
number.
the
that was set.
benchmark. Correct.
think the last question I have just has to do with one of the requirements in the act for legislative reporting. We anticipate issuing an order with specific asks for data and information so we can properly report to the legislature as required under Act 373. Does Entergy have any thoughts about additional information that should be included in that report that the commission should specifically ask for so that we can meet our requirement under Act 373?
I'm actually not familiar with all of those requirements, so I couldn't offer you anything today.
Would you point to any of your other witnesses today that could answer that question, or?
I don't believe our other witnesses are familiar with the legislation or the reporting structure for the legislature, and I'm personally not well enough to sit here today and make recommendations.
Any additional questions?
No, that actually was the one I was going to ask last, so we're good. Thank you.
I think that's all I have.
Could I be permitted just one clarifying
Sure.
question? Thank you. Mr. Palmer, you were discussing with the commissioners the cost and the underlying proceedings. Just to clarify on those costs, is it your understanding that EAL would comply with the cost I am reporting that's going to be reported to the commission in those dockets?
Yes, we fully expect we will comply with those requirements.
Okay.
Yes.
Just to confirm.
All right, Mr. Palmer, you can be excused for the time being.
Thank you.
I believe that's all of your witnesses for Entergy, correct? All right, Ms. Chandler, you may call your first witness.
At this time, I'd call Greg Meyer. Greg, will you state your full name for the record, your title, company, and company address?
My name is Greg R. Meyer. I'm a regulatory consultant. My business address is 16690 Swingley Ridge Road, Suite 140, Chesterfield, Missouri, 63017.
And were you asked to review testimony in this filing on behalf of the Attorney General?
I was.
And as a result of that review, did you author testimony that was filed on April 14th of 2026 in this matter?
I did.
Acting Chair, before I tender the witness for cross-examination, I would like the opportunity to provide additional direct testimony. I understand that under Rule 4.08, normally live direct testimony shall be accepted into evidence unless there's an exception when the sponsoring party shows good cause why additional testimony should be allowed. In this instance, in this docket, as y'all are aware, the only opportunity for the AG's witness to provide testimony is his direct testimony. Rebuttal testimony has been filed to discredit his testimony on behalf of the Attorney General's. I believe that there is no other mechanism for us to provide his opportunity to rebut that discredit of his testimony, and we should be allowed to admit direct testimony regarding that. And under Rule 407, obviously the conducting of this hearing is at y'all's discretion unless it's required by due process. It is our position that due process would require us to put on this testimony to give you a full and complete record to be reviewed.
Ms. Law?
So Entergy Arkansas would object to any direct testimony be entered today. Due process would say that, and the commission rules say that as the party with the burden of proof that we have the last say, and we did in testimony, so it's not appropriate to now bring in additional testimony the day of the hearing without any notice and without an opportunity for us to respond.
Does any other party want to address the AG's motion to allow live direct testimony?
We join the AGs if that helps. We concur.
Can you make sure you speak into the mic, or if it's not working, come up to the podium?
Can you hear me?
Yes.
May I sit?
Yes.
Okay, thank you. Staff would say that the commission issued its order, and staff would have liked the opportunity to rebut some of the things that Entergy said in its reply testimony, rebuttal testimony as well. But the commission's order was the commission's order, and given the nature of the truncated time that we were dealing with, this just wasn't a issue, or possible. So we would object to the additional direct testimony.
Any other party want to address this issue? Ms. Chandler, can you tell me whether you notified EAL before today's hearing that you intended to offer live direct testimony?
I did not notify them, no, sir. Just as they did not notify us that they were going to provide clarifying questions after the commission had ended their conducted their questioning of Mr. Palmer, which is not within the parameters of what the commission has allowed in the past either.
You didn't object to that, though, did you?
I did not.
Just a moment. Ms. Chandler, I appreciate the AG's position on this. Unfortunately, the act limits the time frame in which we can conduct this proceeding. It's expedited for everybody. And so I think I'm going to deny your request at this point, and we'll move on to cross-examination and commission questions.
Would I be allowed to proffer his testimony?
I'll allow that.
I would just note that that is highly prejudicial to EAL, who bears the burden, to have them now proffer testimony after we have, you can't unhear it once it's heard. And so that, I mean, that really disrupts the entire procedure and fairness of having a hearing and a procedural schedule to show up the day with additional direct testimony.
I appreciate that, Ms. Law. The chair this morning allowed folks to proffer opening testimony that is not normally allowed as well. So I'm inclined, for purposes of appeal, to allow the AG to proffer testimony in this case as well.
I'll just offer, though, that opening statements are not evidentiary. This is evidence that now the company will not have an opportunity to respond to, which is a due process violation. We are the party bearing the burden of proof, and I think the commission's rules specify we would have the last word on that. And so now to allow this and not allow us an opportunity to respond is, it violates that right.
You will have an opportunity to cross.
But that's not the same as the opportunity to present direct evidence in response. And I would also be being asked to cross on information that we've not heard before until today.
Ms. Chandler?
Yeah, I believe that due process allows us to put this evidence in front of you all for a complete record, and it's our position that Entergy has the ability to have the last say because they have the ability to cross-examine the witness. And so they have the ability to make the points that they want to make regarding his testimony, that any testimony that's presented here today.
Ms. Law, I appreciate your arguments, but I'm going to allow the AG to proffer the direct testimony. Proceed, Ms. Chandler.
Mr. Meyer, were you provided with an opportunity to review Mr. Morey's rebuttal testimony?
Yes, I was.
And do you agree with Mr. Morey's position that your use of short-term debt is inconsistent with the Gaza Rider and Act 373?
I don't agree with that. When I looked at the bill and I looked at the tariff, and in the bill, I could not find any reference that said that the QUIP capital structure had to be based off of the last rate case. Instead, what the bill says is that the capital structure must include short-term debt, long-term debt, and equity of the company. That can be completely different than what's included in a rate case. The tariff also mentions,
Mr. Meyer, if you'll please pull that microphone a little closer to you.
sure,
That way we can make sure that we've got
is this better?
that everyone can hear you. Yes, thank
Okay.
you.
Let's see here. Sorry. Okay, on page 22 of the tariff, paragraph E, and I'll read it because I think this is the important distinction. The capital structure and overall rate of return approved in the last rate change will be applied in this Gaza rider to calculate a return on a rate base. Return on QUIP will be calculated using the cost of debt and return on equity approved in the last rate change, and the capital structure will include only the short-term debt, long-term debt, and equity for the rider test period, with a minimum percentage of 30% and a maximum equity percentage of 50%. To the extent that the equity component is outside of these limits, each debt component shall be adjusted to absorb the change in equity on a proportionate basis. That doesn't say that you have to use the percentages in the rate case. The capital structures, first of all, in the last rate case, QUIP is not a component of rate base. So there is a mismatch there automatically because QUIP should be funded with short-term debt first, and then a proportionate of equity and long-term debt. To suggest that there was only $61,000 of short-term debt applied or being applied to a $1.2 billion investment is unreasonable. There are certain things in Mr. Morey's testimony that I do agree with that he stated, and that is that we are not here today to propose that short-term debt should last for the entire period of a long-term asset. That is not our position. Our position is that more than $61,000 out of $1.2 billion of CWIP plant should be utilized to calculate the return. We recognize that once the asset is constructed or moved into plant and service or at a certain point during its construction phase, that it will be necessary to convert the short-term debt to long-term debt or equity. This is a basic financing theory that minimizes the cost of QUIP while it's in a construction phase, and utilities should continue to strive to have that reduced rate when it's including QUIP in a return. The QUIP return and the AFEDC rate should be almost identical, and the Uniform System of Accounts prescribes that short-term debt is to be used first, followed by long-term debt and equity. So if they put it out first, you should be able to make a conclusion that short-term debt is to be used, to at least in some proportion to finance this QUIP while it's in construction. You heard from Mr. Lewis earlier that Bondbright says that it should be used as a bridge, and that's been my experience, is that short-term debt is used as a bridge until such time as the project reaches more maturity or that the short-term debt limits have been reached, and then that's converted into more permanent financing. But the way it's being presented here now is requiring a enhanced return on QUIP to the benefit of the shareholders.
Is it your position that the entire debt should be financed by short-term?
Absolutely not. It's a proportion, but it's not $61,000.
What is the benefit to ratepayers to allow short-term debt to be increased for financing?
Well, short-term debt, and I think that was reflected in a cap structure that Entergy provided. Short-term debt is the cheapest form of debt and the cheapest cost of finance. I had some, in this filing, short-term debt was, or what they included was 4.23%, long-term debt was 4.89%, and equity was 9.65. When you move dollars out of long-term debt and equity into short-term debt, that creates a lower rate of return on the QUIP balance and allows for what I call the prudent management of the construction costs. And it lowers the cost to consumers just by utilizing short-term debt in the time during construction.
I'll pass the witness. That's the conclusion of my proffered testimony.
Ms. Law, Cross?
Mr. Caballero is going to conduct cross for us, but I did want to
Okay.
make a motion that none of the proffered testimony be given evidentiary weight. Nothing that was just stated now was not available to this witness prior to his direct testimony being due. Nothing was actually responsive to what was in Mr. Maury's or appropriate for that. So I would just reiterate that motion.
Mr. Caballero?
Can we respond to that motion?
Sure, go ahead.
I would reject some of the characterizations of the motion just made. If you look at the rebuttal testimony filed by Mr. Maury, he characterizes Mr. Myers' testimony as wanting short-term debt to finance long-term debt. He even uses an analysis of comparing financing short-term debt to a 30-year project. That is clearly not what we're saying, and that's clearly not what he was presenting in his direct testimony. As such, I would disagree with he is stating stuff that could have been provided in his direct, because this issue just came up in the rebuttal for Mr. Maury. So for that reasons, I would push against that motion just made, and a lot of this is in response directly to the rebuttal. Thank you.
Thank you, Mr. Lewis.
Good afternoon, Mr. Meyer.
Afternoon.
Proceed.
Thank you, Commissioner. Mr. Meyer, you do agree that you said in your testimony that EAL relied on the amounts and cost of short-term debt, long-term debt, and common equity last approved by this commission in docket number 16036 FR, correct?
The current, yes, I do.
And I would like for you to read from the statute. You can read sub D, please. 23-4-1304 M1D.
Can you tell me what you're having him look at?
Yes, I'm having them look at Acts 373, 23-4-1304, section M1D.
Okay, thank you.
So I'm just want to make sure, does it start with for the purposes?
Yes.
Okay. D, for the purposes of the rider, the cost of debt used in calculating the cost of capital shall be the cost of short-term debt and the cost of long-term debt approved in the investor-owned electric utilities or the investor-owned natural gas utilities, most recent general rate case proceeding, or formula rate plan annual filing. I don't have any problems with that standard, but that standard does not tell you.
But docket number 16036 FR is the last approved rate case for FRP for EAL, is it not?
But if you let me finish, this section talks about costs. It doesn't talk about amounts. And that's the whole issue. It's not the cost. No, we're not challenging the cost of long-term debt, the cost of short-term debt, or the cost of equity. What we're challenging is the fact that there's only $61,000 of short-term debt being applied in the rate calculation, which is not covered by D.
And Mr. Meyer, are you aware that in the CECPN filings for Ironwood, Jefferson Power Station, and Cypress Solar, EAL identified that it would anticipate financing those resources primarily with first mortgage bonds, long-term debt?
Well, if they did, that's a mistake well, let me back up. If that statement was made when the plants are in service, I would agree with that. If the statements were made that during the construction phase of those assets, I would strongly disagree because it doesn't result in the lowest form cost financing for the customers.
So are you aware that the AG participated in those proceedings?
I am not.
Well, would you be surprised if I tell you that the AG did not make a single objection in those proceedings to EAL's proposed financing of those resources with long-term debt?
I'm not going to speculate on the AG's positions in those cases.
Oh, no, it is in the docket, so I don't have any further questions. Thank you.
Mm-hmm.
Ms. Kelleher for staff?
Staff has no cross.
Any redirect? Ms. Anderson or Commissioner Anderson?
Thank you, Commissioner Tate. Mr. Meyer, I want to circle back to a document that we have looked at previously. It's the response to deficiencies, document 48. Do you have a copy of that, or does council have a copy he can look at? It's the document we were discussing earlier, response to deficiencies, document 48.
Okay.
Mr. Meyer, were you in the room for that testimony previously?
I was,
Okay.
but I can't tell you I followed it a lot.
You can't tell, oh, that you
Can't tell
followed
you
it
that
a lot.
I followed it in detail.
Well,
Go
and
on.
I'll just ask you generally then.
Okay.
So let's look at the Ironwood CT. Do you see the chart or the graph that is, Ms. Chandler, you may have to help him. We're looking at Ironwood first. And these are just your thoughts in general, okay?
Okay.
Do you see the bottom of that first box where it says grand total? 781,972,000.
I got it.
Do you see that?
I
Okay.
do.
And that's at the bottom of a column, or both columns actually, the original approved funding and the current approved funding.
Okay.
As we were discussing earlier, when the commission had the hearing on the Ironwood CT, we can call it a cap or a benchmark, but that was set at 542 million approximately in that case. Can you help me, or can you provide your thoughts on whether or not it makes sense that the filed numbers here reflect amounts in excess of those capped amounts by the commission in this particular docket or let's just stick with Ironwood? Is there anything you can offer to help us help that make sense for us?
Well, I think, well, these are the current cost projections to do Ironwood. Okay.
Right.
What would be troubling from my perspective would be if I approved a $540 million call it what you want, benchmark cap, that's your expectation. If it's now 780, I think that there should be some type of reconciliation filed to determine where those costs have increased and why.
Because what impact would that have in your mind if the number was in fact 781.9 million?
Well, the difference between 550 or 540 and 780, obviously I can do that math. That's 240 million. That's going to be 240 million more that customers are going to have to pay plus a return over the life of that asset. So it's big money.
Okay. Is it easy enough for him to pull up the Jefferson Power Station as well? Because the dialogue is similar there, although the difference is not as great.
It should be, but I'm computer challenged.
That's okay. I find that I am ending up drowning in paperwork up here, and I can't ever find what I'm looking for by this time of the day. It's okay. So in that particular graph, that's the Jefferson Power Station. You see that the grand total there is 1.6 billion, correct?
Correct.
Okay, and in that particular docket, the cap was at 1.5. So I'm assuming your analysis would be the same as far as the impact.
Right. But I think, in all fairness, I think that the utility should have the opportunity to explain why it's gone from 1.6 to 1.5, except for just a general statement says, well, that's escalations.
Sure.
I think they should be given an opportunity to explain those increases and justify them.
Okay. All right. Shifting gears just a little bit. Mr. Meyer, you also heard the previous testimony about which parties are permitted to file deficiencies in a docket like this. I take it you're not wanting to answer this question either. In your opinion, should all parties be able to file or be permitted to file deficiencies?
Well, let me say this. It's a very compressed schedule, and that raises questions. And I think that at some point, the commission has to decide which party can provide the most, because you could have, I'm not saying it would be done, but you could have the bias that someone would just file a deficiency just to make sure the process got delayed so that they could devote more resources to it or whatever. So I think that if you decide which parties or party would have the most or the least unbiased to provide that overview, that's where you should go. Now, that party should also, for instance, we know the AG office is in almost all the cases. I think that it would be appropriate for the staff to reach out to those parties and say if there is anything that they've identified prior to them filing their deficiencies, because if that deficiency was just possibly overlooked by the staff, then at least there's an opportunity to have it included. But I think that if you open it up to everyone, that may not make for the most efficient schedule.
All right. That's all I have. Thank you, Mr. Meyer.
You're welcome.
Just one question. For utility financing projects like this, would access to a tariff like this or access to CWIP change how they might finance a project?
It shouldn't. And let me tell you why. The substitute for CWIP is AFEDC. And AFEDC is the rates should be comparable. And when you see debt, short-term debt balances like this, that should raise questions. We know that the parent, I think I put it in my testimony, we know the parent has $650 some odd million of short-term debt. We're also aware that there's a money pool at the parent level that you can borrow against at a very low interest rate. And so those mechanisms need to be used in this instance while the plant is under construction to keep the cost low so that customers can afford to pay for this. You know, this is a special regulatory mechanism. Let's not dance around the thing. This is a special regulatory mechanism that allows QUIP to be collected in rates and allows utilities to pay for infrastructures outside of a rate case. You know, there should be some analysis or safeguards put into that process to make sure that customers are receiving the lowest cost financing available. And that's by using more. They should have to be required. One of you asked earlier, I think you asked Mr. Palmer, what would you do differently in this process? Or what suggestions might you have? I think that more justification than just pulling a number from a docket should be used to justify the level of short-term debt in these calculations. And the utility should be required to show that it's maximized its level of short-term debt borrowing to fund these construction projects up into a certain point when it's converted, like we agreed, to long-term financing options.
Thank you, Mr. Meyer. You may be excused. I think next we have Ms. Kelleher.
Thank you, Commissioner Tate. Staff calls Mark Herring. What is your name and title and street address?
My name is Mark Herring. I'm Public Service Rate Case Analyst 2 in the Electric Utilities section, and my address is PS Arkansas Public Service Commission, 1000 Center, Little Rock, 72201.
On whose behalf are you appearing today?
General Staff.
Are you the same Mark Herring that filed responsive testimony on April 14th, 2026 in this docket?
Yes.
If I asked you the same questions today, would your answers be the same?
Yes.
Are you also appearing to address issue number 1 and order number 5 in this docket?
Yes.
All right. Pursuant to the Commission's order, that the testimony's already been admitted, we tender the witness.
Ms. Law, cross-examination.
No cross for Yale.
Mr. Lewis.
No cross.
Commissioner Anderson, do you have any questions for the witness?
Mr. Herring, you heard the couple of conversations we've had so far about the two Excel spreadsheets with the project total numbers in them. Do you recall those? And did you hear that discussion?
Yes, ma'am.
Do you have anything to add to that as far as the impact and the numbers being, for two of the projects, being above what the cap was set, where the cap was set by the commission?
No, not really. I would just say that there would have to be I think a reconciliation or some kind of explanation as to the differences of those two numbers.
Okay. Any specific form for that, or just?
No, nothing I can think of off the top of my head. No, ma'am.
Okay. All right. Commissioner Tate, that's all I have. Thank you.
Mr. Herring, I don't believe I have any questions for you. I think we may have missed this with the transfer of responsibilities from Chairman Webb to myself for this hearing. We typically will admit at the beginning of the hearing all pre-filed testimony, and I don't know that we've done that in this case. So if none of the parties object, I'm going to go ahead and do that now so it's clear on the record that that testimony has been admitted. Does any party object to filing or to admitting all the pre-filed testimony here? Okay. I don't have any questions for you, Mr. Herring, so you may be excused. I appreciate it.
Thank you, Commissioner Tate. Commissioner Anderson.
Thank you, Mr. Tate, Commissioner Tate. Staff calls Brian Seitz. Please state your name, your title, and your business address.
Brian Seitz, Director of the Financial Analysis Section, 1000 Center Street, Little Rock, Arkansas, 72201.
Okay, and on whose behalf are you appearing today?
The general staff.
Okay, and what is the purpose of your appearance?
Item number 2 and order number 5 from the commission.
Okay, did you file pre-filed written testimony?
I did not.
All right. To qualify you as an expert, what is your educational background and professional experience?
I have undergraduate and graduate degrees in business and finance. I have 20 years of experience in portfolio and investment management and research. I have a further 10 years experience as an individual business owner, and I've been with the commission since September of last year.
Have you previously testified before the commission?
Yes,
Okay.
I have.
Do you recall what docket?
25070.
All right, thank you. We tender the witness.
Ms. Law, do you have any cross?
We do not.
Can I make a correction? My testimony was in 25064, I believe, not 25070.
Thank you. AG, no cross? Commissioner Anderson?
I don't have any questions. Thank you.
Mr. Seitz, you heard the testimony about short-term debt to finance these projects. Can you discuss the pros and cons of using less short-term debt to finance these projects? Or what impact that'll have?
Specifically for Entergy?
Yes.
Due to the rate mechanisms and the way that this tariff has been designed, because the long-term debt, like the equity, is at a higher rate than the short-term debt, it benefits the shareholders to use those higher numbers in terms of generating the rate, rate of return calculation, and they are even further advantaged since the CWIP calculation removes the zero cost liabilities. The shareholders, not.
I know you're not an attorney, but do you think Act 373 permits the commission to change a utility's short-term debt amount?
I do not, but I'm not an attorney.
Did you hear some of the questions I had for, I believe it was Mr. Palmer earlier, discussing the projected billing unit specifically for residentials across the 3 dockets?
I did hear that.
Are you familiar with the difference in those projected billing units?
I am not. Our section doesn't participate in the billing calculations.
Okay. Are you aware of, or can you articulate a reason why those projected billing units would be so different?
Can you be more specific about, I do have the exhibits. Can you be more specific about what you're talking about?
Sure. The company's projected or forecasted billing units for residential in the FRP is, I believe, 7.8 billion kilowatt hours, while it is 7.5 both in the FRP docket and in this docket.
I cannot address that.
Okay. I think that's all I have. No questions, Commissioner Anderson?
No questions. Thank you.
You may be excused.
Thank you, commissioners.
I think we're about to wrap this up. We're going to take a 5-minute break to make sure we've got all our I's dotted and T's crossed, and we'll be back. Let's call it 3:25. I'm sorry? Thank you. All right, recess till 3:25. All right, if everybody's here, you guys can be seated. We'll be back on the record. Yep. Well, let's give the court reporter a second. Are we good? Okay. I think we're almost done. We may need to recall a couple quick witnesses. Ms. Law, I think you identified that Mr. Maury would be able to address a question we had. I think it was in order number 5.
Yes, Mr. Maury was, I believe, prepared to address the second question regarding the debt rate. And then the
yes.
first question, we have Mr. Clutcher.
Okay. Why don't we bring up Mr. Maury then to address that question? All right, Mr. Maury. Can you confirm for us whether are the short-term debt and long-term debt rates filed here the same as Entergy's FRP compliance filing?
That's correct.
They were not originally, though, right?
We had discovered a material issue with one of the rates that we had used. One of the rates that we had used was from the original evaluation report that we made with the 2025 FRP. What I'm about to walk you all through is the discovery of that issue and the remedy of that and how that flows back through the filing requirement 4 that we're proposed to file in compliance to this particular rider.
Okay, go ahead.
So that's okay. Do you all have a copy of?
Do you have hearing exhibits for us?
Yeah.
So this was a hearing exhibit we emailed to all the parties on Monday before the
Okay.
deadline. So I'm happy to pass out copies, but if folks have it digitally, they're welcome to use it.
Ms. Law, are you wanting to admit this?
And let me know when you all are ready.
I think everyone's got the exhibit, so when you're ready to
Okay,
walk us
sure.
through it.
So I know there's a big stack of papers with a lot of numbers on it. So what I'll have you all focus on are the first 3 pages of this packet. So it's going to be page 1, page 2, and page 3. So I'll start from page 3. So page 3 represents the original cost of capital calculation that was included in the 2025 FRP evaluation report. So that's going to show the long-term debt cost rate, which is on line 1 of that page. It's 4.8864%. Through the post-filing activities that occurred in the 2025 FRP, that cost rate was later changed to 4.8150, which is shown on page 2 of 37. And that's line 1 of that page. So I would also have you focus on, for this particular page, line 15, column F, which is the benchmark rate of return on rate base. So that is 5.76 for the compliance filing, and then 5.79 for the original filing, which is on page 3, the same line, same column. So once you get level set on those 2 percentages, if you flip to page 1 of 37, you'll see to the right-hand side 3 columns. So one's updated, one's original, and then one's changed. The updated equals the compliance filing. That's on page 2 of 37. And then the original column ties to page 3 of 37, which is the original calculation from the evaluation report. So you'll see the 5 on the first row, benchmark rate of return per 2025 FRP docket number 1636FR. The update there is 5.76%, which is what you saw on page 2. And then on the original column, it's 5.79, which is what you saw on page 3. So the way this calculation works then is that gives you how it impacts the GAJA rider. So ultimately, at the end of the day, what we determine is as a result of those changes is that the total revenue requirement decreased about $462,000. And that's the reconciliation on how we got to that reduction in revenue requirement. And after page 3, I think so pages 4 through 37 are what we're proposing to include as part of our compliance filing for this rider. That includes the changes that we just walked through.
Which page?
So that's going to be the pages preceding or after page 3. So page 4 of 37 going all the way through.
Oh, the remainder. Okay.
The remainder, right? Yes, sir. So that's going to be that's going to include the changes that we would propose to include in the compliance filing for this rider.
And when do you intend to file that?
That's. Do we know when we're gonna?
I think we had anticipated that we would make a compliance filing after the commission's order that would include, just like we do in the FRP, all of the items changed. But we're also happy to admit this into evidence today, which is an updated compliance of the entire tariff filing.
So you're moving to admit this today. If we admit this today, you'll still also file it as a compliance filing post commission order?
Yes, sir.
Okay. Do any of the parties have questions on this specific issue or the exhibit that's been presented? AG, staff? Okay. No objection. I'm going to admit this into evidence. Do you have any questions, Commissioner Anderson?
I do not, thank you.
Okay. 1 second. I think you can be excused, though.
Okay.
Thank you.
Thank you.
I apologize. We're still having some technical difficulties, so I can't access all the documents I need to. Ms. Law, you mentioned that you had Mr. Clutcher here to address the first issue that was identified in order number 5.
Yes, sir.
If Mr. Clutcher would like to come up to the microphone. All right, Mr. Clutcher, you're familiar with our order and the question that we presented?
Yes.
Can you go ahead and address that specific issue, providing an estimate of EAL's rates for all sectors for the first billing cycle in January 2026? And do you have any exhibits you want us to walk through as you do that?
I do have an exhibit that we can walk through.
Ms. Law, do you want
We
to?
also provided this to the parties.
Okay. All right, whenever you're ready, Mr. Clutcher.
Okay. So in addressing question number one, which was asking for EAL's rates for all sectors, it also requested it by a January rate and a June rate. So in order to answer that, wasn't entirely clear exactly what the commission was looking for. So I kind of offered up a couple of different bill impacts to address this question. So the first thing I did was I put together what you typically see in our filings is a bill impact at the what we call the rate schedule level. So by residential, small general service, large general service, et cetera. And I did that both on using June rates and January rates. And again, I wasn't clear as if we were looking for what we typically do is we use a 12-month average monthly bill impact, but here I also provided what the bill impact would be in the month of January versus in the month of June. And the difference between basically January and June when you think about the current bill or the other riders using the bill is really fuel. Fuel is pretty much the only thing that changed significantly between what was being billed in January versus what would be billed in June. And so the first page, page 1 of 3, that is your average annual monthly bill shown both on January and June impacts. And so again, the GAJA is the only thing that's changing between the current bill and the total bill or the proposed bill. And then again, the underlying riders, pretty much the only thing that changed that was significant was the ECR. So I'll pause there to see if there's any questions on that first page. No questions. The second page is essentially the same information except instead of a 12-month average bill impact, that is the January typical bill and the June typical bill. And again, the difference here will be is we have seasonal rates in many of our rate schedules. And so you have a different underlying base rate in January than what you do in June because we typically have higher base rates in June versus January to reflect the different costs of providing power during the summer months versus the winter months. Any questions on that before I move to page 3, which actually looks at EIA data?
Go ahead.
Okay. So the final exhibit is now trying to address the question kind of talked about all sectors, and that led me to believe you were probably asking about the EIA data, which is also part of the constraint for the rates in the GAJA rider. So what I provided in this particular exhibit is going back to 2016 up through 2024 using the annual report from the EIA data, which is essentially the same information we just provided as filing requirement number 2. So again, if you look to the far right there for the 2024 data, that would coincide with what you saw in the filing requirement number 2. So that's using actual EIA data up to that point to answer that question. Again, this is all sectors, so this is total utility. It's not broken down by your revenue classes of residential, commercial, industrial. Now, try to carry it out further through 2026. So the first step I had to do was account for 2025. Again, as I mentioned earlier today, 2025 will not be available until October of this year. But what is available from the EIA is what they call their monthly reports. And so utilities actually report, or most utilities, not all, but most report on a monthly basis. And so you can also get the monthly information. But I'll point out that once the October one comes up, say for example for 2025, it won't necessarily match exactly to what you get if you use the monthly. So this is more of an estimate of what you may see when the actual report comes out later this year. But that takes the 12 monthly reports from 2025 and calculates the national average, and it calculates EAL's cents per kWh. And I've also included there as in the middle there with the line with the triangle, that is the constraints. That's 10% below the national average. And then the final piece of information I included was projected 2026. And the way I calculated that was I started with our 2026 forecast and added in 50% of the GAJA revenue that we would collect this year. And that's based on the fact that that rate will start in June. And approximately, if you take the kilowatt hours from June through the 12 months ending next year, approximately 50% of my kilowatt hours will occur this year, and the other 50% will occur next year, which is why I included approximately 50% of the GAJA revenue. to give an idea of what 2026 revenues or 2026 cents per kWh may look like for Entergy. And for the national average, I also said that since we're looking forward a year, I also want to try to pull forward the same data for the EIA, which won't be available obviously until in the future. So what I looked at was if you look at the most recent 3 years, the national average has increased by about 3.3% per year. So I added a growth over the 2025 number by 3% to get to the 14.04 that you see there. I'll pause there to see if there's any questions.
Okay. You have any questions, Commissioner Anderson?
No, thank you.
So I see you, based on monthly, well, for EAL, you have 9.34 for 2025, which is a decrease from 2024.
That is correct.
Can you tell me what is the cause of that, or what you can point to?
So, I mean, really, I think a lot of that's going to come down to it's your revenues divided by your sales. And so if your revenues don't change drastically, but your sales go up, and you have more sales to divide your revenues by, so your cents per kWh comes down. And you can probably see, looking back at Entergy, you've probably seen things go potentially up and down before. You can go back to 2018, you can see we were at 8.33, fell to 7.4 in that year, and jumped back up to 8.53 the year next. Weather's probably the biggest factor when it, driving things like that would be my guess.
These are not weather normalized.
These are not weather normalized sales. That is correct. EIA data is actual sales versus actual revenues.
Okay.
But I will point out in 2026, that would be weather normalized, right? Because I use the
Sure,
forecast. And so our forecast is always weather normalized. And so obviously when the real time comes, Entergy's will go either up or down depending on weather.
Okay. No, thank you for that clarification. Any questions from the AG or from staff? No? Any objections to admitting this? No objections? All right. This exhibit will be admitted. I think the last thing we want to do is, I have one follow-up question. I don't know if Commissioner Anderson has anything for Mr. Palmer. It was a question that I think we previously asked Mr. Clutcher, and I think he deferred to Mr. Palmer, and I neglected to ask it when we had the opportunity. So if you don't mind having Mr. Palmer come back to the table real quick.
I certainly don't mind. I don't know if Mr. Palmer minds, but
I'm sure he does, but I believe the question I had previously asked had to do with what was projected to go through the rider this year versus what is filed here. I believe that number originally was $7 and some change, and the amount that is shown here for this year is $5. A little over. Well, I don't remember the exact figure, but it's $5 in the range. Or in that range, it's less than what was previously projected. Are you aware of the difference generally?
Generally, yeah. And
Okay.
Yeah.
Can you speak to what is causing the difference between, or why there is a difference between what was projected versus what is going through the rider this year?
and the projection you're referring to is from last year?
Yeah, I don't recall which docket we asked for it, but we asked for a projection of what you think the bill impact will be for the projects you anticipate going through the rider this year.
Yeah,
And
I'm with you. I'm sorry.
Yep, go
I
ahead.
think the primary is just some year-to-year changes in the costs. So like I said, we're forecasting our capital outlay for each resource for this period. And some of those numbers have shifted year to year or in magnitude. That's the primary driver.
So, and again, I've apologized. I don't remember which docket that was in. We asked not only for what you anticipated going through that rider this year, but also 5 years out, the next 5 years.
Correct.
How will, if less is going through the rider this year than was projected, how will that affect the projections for the next 4 years?
I don't know that I could state a actual correlation today because it just depends on, if it's a delay because of a substation pad issue or something, and then there's catch up, I don't know that it materially changes any subsequent year.
You think the remaining 4 years will stay same as that was previously projected?
I don't know sitting here that we are projecting that they will materially change based on the fact that this year changed. All those projects are just really getting started.
Can you update those projections since we now know what's going through this year?
Update in the 5-year projection as we did in 25049 TF
Yes.
with the new, I don't know why we couldn't. We have,
Okay. I
you
think
will file it
that's-
in this docket.
Yes, that would be yeah, I think it should be in this docket unless, Commissioner Anderson, do you have a preference?
No, I agree. It should be here.
Okay.
Okay.
Maybe Ms. Law that wants to answer this, but there's a few things we've asked for here. I think one was specifically addressing the FERC filing and accounting for what that line item,
Yeah.
what's in that line item.
I tried to take a look at that during the break to refresh my memory. We can certainly provide some detail as to what's in that account, and then we'll just be mindful of any contract issues.
Sure.
Go from there.
That along with an update for the 5-year, what is being projected to go through the rider. And I believe the last one that was asked for was an estimate of, I think Mr. Clutcher provided an estimate of all sectors, what that
Right. You
And
asked for it by sector.
yeah, by sector. And when do you think you can provide that to us? Does Mr. Palmer want to make commitments on behalf of his?
Yeah. I
fellow
can
employees?
provide it as soon as Matt gives it to me.
Well, as we've discussed quite thoroughly today, we're all under a fairly short timeline, so the quicker the better. So how quickly do you think you can get that to us? Friday?
By the end of this week.
You think you can get all of that stuff to us? I know you're committing to Friday. I'm sure somebody else will be responsible for the other stuff. Is Friday sufficient time to get that to us?
Close of business Friday. We will endeavor to meet that deadline.
Okay. Thank you, Mr. Palmer. That's all I've got.
Anything else?
No.
Okay. Thank you.
Anything else we need to address? Okay. Yeah. Okay. Before we wrap up, is there anything else we need to take up? The parties would like us to take up? AG? Seeing none, we're going to leave the docket open for commission questions and to receive those filings from Entergy. With that, we're done. So we will adjourn the hearing today. Thank you all.
Thank you all.
Great job, Chairman Tate.